Can I welcome members to the 54th meeting of the Committee for Justice? Can I advise members that the committee meeting will be recorded and broadcast throughout Parliament buildings and online? Can I advise members and those in the public gallery that they are welcome to use mobile devices as long as they are in airplane mode and all devices are muted? Attendees can also connect to the Assembly Wi-Fi and password details are available on the gallery rolls. It is not permitted to take photographs or record any part of the meeting. Can I advise members that it is proposed that both oral evidence sessions on the Repeal of Vagrancy amendment with RetailNI and then with Homeless Connect and the same community, as well as the oral evidence session with officials from the Department of Justice on the Strategic Framework for Youth Justice, will be recorded by Hansard. And can I seek the agreement of the committee for that? Agreed. Can I remind members that they are obliged to declare any financial or other relevant interests that might reasonably be thought by others to influence their approach to the matters under consideration. Any members who have interest to declare in relation to today's business should do so now or when the particular matter arises. Can I ask members whether there are any interest to declare at this stage?
Yes, obviously I'm a member of the Homelessness All-Party Group.
Okay, Danny, going ahead.
Yeah, just an immediate family member, works for probation board.
Okay, thank you. And Brian?
Yeah, member of the APG on homelessness and also member of the Finance Committee. It's relevant to one of the letters later.
Any other members want to declare an interest at this stage? Or are we content?
We always just note we're members of, there's a number of us a member of the Access to Justice
Yes,
All-Party
of course,
Group.
yeah. Okay, thank you. Agenda item number 1 then is apologies. Are there any apologies? No, I don't think so. Can I advise members that committee members Connie Egan, Danny Becker and Doug Beattie are attending the meeting virtually, and they're on the screen. Agenda item number, and there's Maurice Bradley in there also on the screen. Agenda item number 2 then is draft minutes. Can I inform members that the draft minutes of the meeting held on Thursday, 6th of November 2025 are pages 5 to 17 of the meeting pack? Can I ask members if they are content that the minutes are a true reflection of the proceedings of the meeting held on the 6th of November 2025? If so, I will sign the minutes. Members content?
Agreed.
Yeah, agreed. Agenda item number 3 then, matters arising. Can I ask members if there are any matters arising from the minutes that they wish to raise at this point? No? Okay. Agenda item number 4 then is the Justice Bill, Repeal of Vagrancy Legislation Amendment, RetailNI oral evidence session. Can I refer members to page 19 to 31 of the meeting pack for the relevant papers? Can I inform members that today the committee is receiving oral evidence from RetailNI on the planned departmental amendment on the Repeal of Vagrancy legislation? The witnesses provided evidence today are Glyn Roberts, Chief Executive of RetailNI, and Chris O'Reilly, Vice President of RetailNI. You're very welcome to the Justice Committee, gentlemen, and can I invite you to make an opening statement? Thank you.
Well, Chair, thank you for the opportunity to present today. I'm going to just run through our thoughts on what's being proposed from a policy perspective, and my colleague Chris will talk through about his lived experience as a business owner. I think when we look at this, it is right and proper that 200-year-old legislation is looked at, and I think certainly that is the case. And I think it is very much the need to update it in the context of the many challenges facing 21st century town and city centres. But I think our view is that the Minister should replace, not repeal, these laws, and updating them with input from business, the PSNI and the charitable and community sectors. And indeed you're hearing from the charitable sector just after this. And we believe that to this challenge, there is no policing solution. It has to be a multi-agency, multi-departmental approach to the many challenges to this problem. And I think that there is, a look that we can take of what the Republic has done when they provided a degree of comfort for business owners, what Gardaí are in power to direct individuals to move on if they are begging at certain designated locations, such as ATMs, vending machines, night safe dwellings, or the entrance to a business premises during opening hours. While it is welcome to have such powers available, reassurance is only obtained through rigorous enforcement. And many of our members have concerns about the potential for an increase in nuisance behaviour associated with street activities such as aggressive begging or antisocial behaviour. And in the absence of such proper legislation, it is not unreasonable to want your trading space to be safe and consumer friendly. And we support new, modern, targeted powers that allow authorities to address genuinely disruptive or intimidating behaviour that could negatively impact trade and public safety. And I think it is, we have considerable experience within RetailNI. I myself sit on a number of the different working groups at Belfast City Centre, and there's no doubt that we face a significant challenge with many people who are on the streets, that have drug and alcohol problems, that have addiction problems, that have mental health challenges. And it is only that multi-agency, multi-departmental approach. That's the only way forward. There is no policing or criminal justice solution solely for this. We have much work to do to address that problem. So with that, if I can hand over to my colleague Chris, he's going to talk through his own experience as a business owner.
You?
Thanks very much for the invite and the time to have a conversation with you. It's a very challenging environment. I have 5 convenience stores across Belfast, 3 post offices located within them, so we're a bit of a hub in some areas of the local community. High footfall locations, 2 on the Ormer Road. And over the last 3, maybe 4 years, I've noticed this becoming, probably since come out of the pandemic, this has become bigger and bigger and bigger to a point where it can become almost a weekly occurrence. I myself have been involved in altercations with individuals who have threatened violence, threatened the business, to burn the business. This morning I found myself turning on the sentry mode on my car, which will record my car, because I parked outside one of my stores, and an individual I've been having difficulty with over 2 years recognised me getting out of the car. I had to go into the store. I had to turn the security on, but I felt intimidated is the honest answer to that. And if we give that as a little bit of a case study, this individual has been begging on the Ormer Road for 2 years in proximity to one of my shops. On one of the occasions, almost 2 years ago, we refused him and his partner entry because they were both extremely altered and they were difficult to deal with as they came into the threshold of the store. On that day, the individual threatened a 20-year-old female worker, threatened to wait for her after work to target her, threatened the manager of the store, and then I have another store 500 yards from that, went down there knowing it was in my ownership and actually put hands on the manager in there to vent his frustrations, and we got a criminal prosecution put against that individual. That was 18 months ago, and that individual still sits 20 yards from my shop regularly, daily, and my staff have to go and face that individual every day. And police have very little power. Police have very little follow-up power because necessarily there isn't necessarily a crime being committed. But I think it's an absolute crime that I have to have my staff who have been threatened, who have criminal conviction put against that individual, who have to walk past him every day. That individual, for no reason, a couple of months ago, as we were outside the front of one of the shops discussing with the manager what we needed to clean and the day-to-day of the front of the shop, he decided to turn on me as he was walking by. And again, yes, you could phone the police and say, get witness statements and do whatever, but it's not the best use of police time to be rolling after such a thing. So for the law, and I put this to the Minister when she kindly hosted us to us, for the law to just almost make it a little bit easier when the problem appears to be getting a little bit bigger, and the problem appears to be a more modern problem that isn't reflected in the current legislation. I absolutely endorse some of the findings that Dr. Brown had put out in his paper. It took me a while to read it. It was really well articulated. I could never have brought it together in the way that he articulated it, but it did seem extremely sensible, and the ROI approach to it does seem to give police power to that. And when I've phoned the police for the 25th time about this individual, they're frustrated because they don't really have any power really to come in and actually say, look, you're here every day. Why are you here every day? Sharps are now starting to appear on the Ormer Road. My newspaper supplier at the front of one of the shops, we have a 24-hour access place where the newspapers get dropped off at 3:30 or whatever in the morning. Sharps have started to appear in it. Sharps have started to appear in my neighbours' alleyways to the side. And I'm not saying that individual who's doing that is responsible for it, but you're beginning to see a cycle of decline, and there are 5 or 6 regular faces that will appear on the Ormer Road in frequency. Some of them don't cause any problems; they just do what they do. Other ones, I could show you CCTV in my phone from 2 nights ago where an individual came in. He's a regular on the Ormer Road. He ripped signs down inside the shop. Gave out because we basically didn't have an ATM available for him, and he wasn't happy with what he heard. So I've 18, 19-year-old students in there of an evening because they're not available through the day, a reasonably mature supervisor, but again they're not there to sort of manage those complex and difficult problems. And unfortunately for many businesses, that's the way things are going in a high urban, high footfall environment, and it seems to defy logic to me that you would almost make this environment a little bit easier. I am absolutely minded that there are people who are in need, and it's a complex and a complicated issue. But on the other hand, I'm trying to create employment, pay off the debt that I have, and provide a service within the community. And this feels like a deal. It feels like as I say, it's a weekly occurrence, but this feels like something that just continues to basically get a little bit worse.
And just to, maybe if I can reinforce some of those points, I had a good conversation with a number of senior police officers about what is being proposed, and their analogy was, look, we don't need the toolbox thrown out, we need new tools in the toolbox to address this problem. And so very much the PSNI would be on the same page as us, and I think their views are absolutely critical in terms of trying to define what success looks like with this problem. Thank you, Chair.
Okay, thank you very much, Glyn, and Chris, for your presentation. With regards to the evidence that we have received over the past number of weeks from the Professor that you have already alluded to, he did propose a new, if you like, a new amendment or a new law, proposed new provision, begging, causing harassment, obstruction or public order concerns, and that would basically give the constable the power to direct a person who is begging in any place in whom the constable reasonably believes is to be acting or has acted in a manner that harasses, intimidates, assaults or threatens any person. I'll not read the whole thing out, you've read it yourself. Do you think that's the sort of provision that would protect your staff?
Yeah, I do.
Do you think it needs to be added on, or is there anything else that needs to be created apart from that provision?
Well, Chair, you have in England and Wales, the police have access to public space protection orders and dispersal orders, which Northern Ireland doesn't have. Again, this is an area that could be looked at. So I think there's good practice elsewhere, as we highlighted in the Republic of Ireland and the rest of the UK, that could be adapted. But I think the solution does lie in a co-design between, as I've said, the police, business, the charitable sector, some of the service providers. All of that is where ultimately we need to be landing this at, a co-design effort. And I think just to unilaterally repeal and not have something in its place that is fit for purpose for 2025, never mind 1825, I think that is where we need to be at. And I think that this committee, looking at this as you are at this moment of time, I mean, I would suggest there are a number of amendments that could put down to reflect of where we are, the police are, the charitable sector, and indeed what Professor Brown has put forward as well. I don't think that it is beyond the bounds of possibility that we could get something that would work.
The Professor also talks about an offence of trespassing with intent to commit a criminal offence. You did talk about people entering your premises, and that's where some of the problems started. Is something like that also required?
I would try to put it in a, for me, I would try and put it in a little bit more simple layman's terms. I would like to ask for protection where we have an individual who continues to return to the same place and continues to create the difficulties repetitively, day and daily. Some of those can be harassment of customers complaining. Some of it can be entrance into the property, given staff harassment. Some of it can be, unfortunately, shoplifting at times. So that I suppose in layman's terms, I'm looking for something to be able to protect us. It's something a little bit more sophisticated than the criminal laws that we have currently. But that is something I would maybe say that if you had a persistent problem at the end of your house every day and you were frustrated in how you would actually sort of deal with it. My staff are like family. I'm totally reliant on them to deliver for me and for me to protect them as well. And there seems to be some sort of feeling where I can't seem to be able to, rely on being able to phone the police to be able to say to them, look, I have an individual here loitering with intent who has caused problems previously with at the location. Can you help me out on it? Because at this point in time, I'm not really getting responses from police on that. And then again, when you don't have effectively a neighbourhood force who are in the area and you've got that relationship built up and you've got the Bobby on the beat who knows who it is and go along and make things, a bit more proactive, we've got a vacuum here. And I don't feel that if I have a shoplifter, I've got a mechanism to work to that. If I have an incident inside the shop where someone falls and hurts themselves, we've got an instant to work our way through that. But with this feels like a vacuum, and it's a vacuum that feels like it's deteriorating. So I would hope we could come up with something a little bit more sophisticated than just taking it away altogether, because taking it away altogether doesn't feel like it addresses. Doesn't feel like it's addressing a growing problem that we have in Northern Ireland society now, which we didn't traditionally have. The individuals who tend to bring some of this activity tends to be addiction related, and yes, mental health and issues and whatever else. But it almost feels like you're taking a hands-off approach rather than helping us maybe cajole it in the right direction. And also, more importantly, protect my business. I pay, on the Ormer Road, I pay over £1,000 a week on business rates to protect the business. It's very, very hard. We're facing extreme cost pressures over the last 5 years. We've talked about this, I'll talk about this to anybody who listens, but I still continue to go and create employment. I still continue to go and take financial risk. I have personal guarantees set against me to be able to deliver what I do. And I feel that this part of my business isn't protected from legislation, and there's a gap with the police being able to protect me. So as legislators, I would be saying to you, can we come up with something that doesn't feel like a hands-off approach? Can we come up with something that actually, protects us?
Notwithstanding your negative experiences, have you experienced or any research on evidence of organised begging which is coercive, whereby the beggar is the victim in the coercion?
I don't. No, I don't.
I wouldn't be surprised if that practice is there. There is obviously a high level of organised crime that our members deal with on a day-out basis. So I wouldn't rule that out entirely. And as I said, I think one of the other big, and you've got to look at this in the wider context, and I think we make that clear in our submission. We are facing an epidemic, a tsunami of shoplifting, of assault of retail staff, of antisocial behaviour, which is off the scale. We also have a situation where there are hundreds less neighbourhood police officers, and that's why we're very clear that we support the Chief Constable's call for a financial settlement of the PSNI. We need those neighbourhood officers on the ground. We can get all the changes to legislation we like, but unless we have enough police on the ground, and particularly the frontline neighbourhood police, we're never going to solve this problem. We have numerous discussions with the PSNI, and that's absolutely vital, because we'll never solve this problem. And I think we do need to get to a point where we have that proper co-designed approach. And it's just that there are a lot of the charities, a lot of the service providers, where the street pastors, those guys are trying to fill a gap that statutory agencies should be filling. And ultimately, it is vulnerable shop staff that pay the price. And that's why, this committee knows our strong support for the sentencing bill, the forthcoming sentencing bill that has assault of retail staff now made a specific statutory offence. That's good, but ultimately we're never going to solve all of this unless we have enough neighbourhood police officers.
Okay, thank you, Glyn. I'm going to put it out to members now. Connie, you're first up.
Yeah, thank you, Glyn and Chris, for coming in. I think I should maybe declare a bit of an interest in a life before politics. I was I worked in retail in an off licence, and often dealing with people who are under the influence. So I have absolutely no doubt about how difficult some of the situations retail workers find themselves in, and obviously not good to hear that this is getting worse. And I have real concerns around the current legislative framework clearly isn't working in my view, and I do totally agree with what you said, Glyn. This is maybe something that needs a different approach, a multi-agency approach. And I know I don't want to get ahead of ourselves. I know the Minister has said she's keen to explore further ways to protect retail workers in her sentencing bill, but I'm just keen to hear about how you've engaged with the Minister and her department throughout the process of these proposals coming forward.
We've regular contact with the Minister. We had a very good, forthright and direct meeting with the Minister a few months ago. So yes, we're regularly, we work with the police at every level, from the Chief Constable to the officers on the beat. I think they were disappointing. I don't know whether this was a administrative but we actually didn't receive the departmental consultation on this. So this is why we are obviously very keen to give evidence at this stage, because I think both the ideas and the policy perspectives that we have, and indeed the lived experience of what Chris, I think, can be invaluable in getting this bill fit for purpose, and ultimately a bill that obviously delivers real change, not least for the businesses that we represent, but also for many of the individuals that, no fault of their own, find themselves on the street and facing significant problems. So we've always adopted a solution-based approach to this problem, and the Minister is always in listening mode, which is always good to see.
You, Connie?
Thank you. Yeah, no, I appreciate that. And look, I think from my perspective, I do think that criminalisation maybe just hasn't worked, and we do need a different approach. But I think it is important to bring other. I think it's important that other partners come around the table, because I don't think this is a justice issue entirely, and I do agree with you there. So I appreciate you both coming before committee today. Thank you.
Thank you, Connie. Brian?
Thank you, Chair. Thank you, Glyn, Chris, for your attendance and your paper. I think we can all agree that a law which is not being enforced is a bit of a nonsense, if it would be seen as an anomaly if it was enforced. However, I do have strong concerns about the public message of saying we're going to repeal laws on vagrancy and begging, and a message that somehow it's legal now to sleep rough in the city centre and to beg on the streets. I think those things should be discouraged, and I'm aware from many people who have experienced harassment, intimidation, fear, and feel under threat, particularly in parts of our city centre. Recently, 3 weeks ago, I attended a meeting with Belfast One, and it was an interagency meeting, quite helpful. And at that time, there had been a video circulating, which many will have seen, of a brawl in the city centre. And I understand about people who are vulnerable, who have addiction problems, mental health problems. But the consequence for people on the street, that it was frightening for people who witnessed it, people who viewed it. It ended up in the media. One of the people who attended the meeting, who runs an evening establishment, said that since it went out on the morning radio show, he had lost 3 bookings from outside of Belfast. Groups who had booked to come in for their Christmas dinner had cancelled because people saying that they didn't feel safe. So there is a real consequence when people feel the streets aren't safe. So my concern is similar to what you've said, Glyn, about ensuring that the police do have the tools in their kit I'm not sure if we're bringing the police in to give evidence on this matter. Good. Well, I think it's important that we do. So at that meeting, I mean, the senior officer who attended talked about powers that they don't have here, which do exist in England, on public space protection order, civic injunctions for antisocial behaviour, dispersal orders, the enhanced use of community resolution notices, the ability to disperse people and move them on. And it's relevant not just to what we're talking about in retail areas, but also at interface areas where police need to disperse people. So I would be interested, we've talked about this, whether today or in further papers, thoughts you have on specific powers that you think that are lacking here or that would help. And I would also say that we must never treat our city centre and our retail hubs as taken for granted. They are all vulnerable, and especially in the modern era, you know, with online shopping, out of town shopping centres. So those retail hubs are vital for society and for healthy towns and cities and must be protected. They are vulnerable if they're not protected. We shouldn't just assume that they will always be successful. So it's important that we ensure that there are the right tools for the police to ensure that city centres are safe and feel safe for people coming in. So I don't know if you have any specific thoughts on powers that you think should be provided for the police and also for council officers, you know, in bylaws that they can enforce.
Sure, I think that firstly there is the public space protection orders that you have in England and Wales. You have obviously the experience of the Republic of Ireland as well. Just to put into the context, and Brian, I know you represent a part of the city centre in your constituency. We have a member in Belfast City Centre whose every single member of staff has been assaulted. The amount of time that during the week, and it's a small independent business, independent retailer, and the amount of time also that he has staff giving evidence in court, further, you know, 2 or 3 days of court. No worker should ever be in that position or work in that environment. And likewise, not just in Belfast, but many other of our town and city centres, consumers need to feel safe, that they are safe to shop and socialise. And obviously this week I was with one of the assistant chief constables about Operation Season Greetings, which is the big campaign to make sure, certainly at Christmas, that our high streets are safe for shoppers, for people who are going to socialise, for visitors, and for shop staff as well. So I think that is, I hope that we can reassure consumers that our high streets are safe. So I think it is about that, and it's also about, particularly if you look at Belfast City Centre, one of the things we need to do in Belfast City Centre is to make it a living community again. We need to have people, and I think that is the big challenge, how we make Belfast City Centre a living community. That's going to be extremely difficult if we have a problem with crime, antisocial behaviour. So we need to work harder at this, and it gets back again to that multi-agency approach that is there. The police aren't the sole solution to this. It is addressing those many people who are on the streets who have drug and alcohol problems. And you also have a situation in the Lower Ormeau where you have, for instance, I think, is it 20 hostels that have been located? Why cluster so many hostels in one particular area? Which, you know, again, we've got to ask questions, and we've got to have that joined up approach working across not just agencies but government departments, councils as well. So yeah, there's a lot of moving parts in this problem, and it requires a solution that is equally as multifaceted.
Okay, just before I bring Patsy in, can I ask, you talk about the assaults on the staff members, and there is laws to cater for assault, and yes, you alluded to the fact that people then go to court. What will new modernised vagrancy laws help to, will it help to remove those assaults? Can you explain?
In my case, yes, the police could have attended and moved that individual on if they seen that they had
You're saying would have
a
prevented
better
the
way of
assault?
describing us, the tools within the toolbox to go and deal with that individual. Because
Which would, does that mean then it would prevent the assaults from happening?
correct.
Yeah, okay.
Right. So this is one person, but this person, it can be multiplied hundreds of times.
Yeah,
Okay,
of course.
but this one person is a ticking time bomb who sits within proximity of my shop and my staff.
Yeah.
Individual has addiction problems, has a complex life, sympathies and empathy with all of that. My duty care is to protect my employees. And as I say, 2 months ago we're standing outside the shop with the manager and the supervisor, and I'm talking about what we need. Truthfully, while we stand out on the street, I was talking about something else in my shop. Walls have ears, so I needed to talk to them outside. The chap walked by and he tried to intimidate me with a stare, and it was my manager actually said, this can't continue. And as he said that guy sort of kicks off. But that guy's sitting there every day, 5 days a week, and he's a chip against the shoulder because we've had a prosecution against him, but he's allowed to remain and stay.
So, can I ask you then, Glyn, you alluded to the public space protection orders. What's your understanding of how they work?
It is something that obviously we've pulled together. It's something that we have asked for more information about our colleagues in other trade bodies, so we're waiting on further information. Happy again to supply that. But certainly that's one aspect of this, and obviously what they have in the Republic of Ireland, where Gardaí are empowered to direct individuals to move on if they're begging at certain designated locations, such as ATMs, vending machines, night safes, and obviously an entrance of a business premises during opening hours. So I think we don't have to look too far for good practical case studies of where amended legislation can help address this problem.
Okay, thank you. Patsy?
Yep. Thank you for being here and for relaying your experiences. I'm just conscious we don't want to be moving into the situation of one size fits all, because it's a very complex issue. I'm trying to get my head around, because people, not just people who may be vagrant as the law specifies at the moment, could be meeting other people on the streets who have committed serious offences against them and their families. So it's just not people who may be homeless or whatever. And also the other thing is, if that person is aggressive towards you or to a member of your staff, likewise the issue of being resident possibly in a hostel, they may well be at risk, they may well be a risk to residents of that hostel, many of whom are vulnerable as well. So that, in my mind, emphasised the need for a bit of joined up governance here. However, it brings me back to, if that person, like other people who have committed indeed many worse crimes than that individual could have committed, is seen on the street, and the victims of their crimes or meet them on the street, if they have served time legally in that instance, unless they are presenting themselves as a person who's aggressive, who's recommitting a crime, or indeed threatening or menacing towards you, there's recourse there towards the courts already. So I'm trying to get, in my mind, what you expect or what you would see. Now, I make a clear point here. I don't think it's right to get rid of the existing legislation and nothing there better to replace it. That's a key point in all of that, and it mirrors much of what Brian has already said there. But to your mind, you're facing it on the street, right, in your instance. What do you think should be done in practical, real terms, either by multi-agency approach, and what that multi-agency approach should be, including police?
Well, I think the complex lives is a good example of that. But don't get me wrong, Chair, we are not stereotyping anyone. We absolutely realise that there are people we are facing a mental health epidemic. We have people with drug and alcohol addiction issues, and that is not a policing solution on its own. That is all the respective agencies going the extra mile to support those people. It's not saying that all those people that are in a hostel are all criminals. Absolutely not. We would never stereotype or label or anything like that there, because every individual has their own story. It's part of a multifaceted problem which requires a multifaceted solution across numerous different agencies. And at times, government departments working together we don't have a great track record of that sort of multi-agency and silo. It tends to be very siloed. So what we need to ensure that whatever comes up in this, that it works, and we have clear idea of where we want to get to support the individuals that are on the street, but also to support businesses like Chris and their staff who provide an invaluable role in as community retailers, and it's making sure that we can protect them.
I'm getting the principle, but I'm looking for the how, if you have it. That's the sort of area that I want to move into.
Well, again, I think we've outlined the situation or experiences in the Republic of Ireland and indeed England and Wales as a possible solution. And obviously, Professor Brown's own paper puts a number of ideas and solutions. So it is about, first and foremost, modernising 200-year-old legislation, and as I said, making sure it's fit for purpose for 2025, not 1825.
Yes, but looking at your own experiences, if you were sitting like us here, what just practical measures? Say that guy that's intimidatory or threatening or menacing, call it what you will, to you or your staff. What practical measures, and he may well be doing the same thing if he's down the street in the hostel to staff members and indeed other very vulnerable people who are living there in that hostel. So aside from the thing that immediately springs out is that social service and everything should be working very, very closely with the likes of police and indeed whichever agencies in charge of the hostel in that situation to address it. But I'll put it to you another way, how do you deal with that problem and removing from you without creating a problem for some other shop 200 or 300 yards down the street? That's my point.
I would assume there's some sort of, in my mind, there would be some sort of trigger point if that individual continued with the repeat behaviours around displacing themselves at different businesses. Just, at that point it would need to be picked up. But beyond the police and stuff, and as far as the societal stuff or whatever else goes, I'm no expert in that area.
No,
I just literally would feel that if you could have some sort of law that allows when a business owner goes into a place where they're feeling that their business is being unfairly targeted, that you can use the rule of law, you can contact your police authority and they can come out and actually take some sort of action to move that individual away and to tell them to cease and desist the activity that they're actually involved in. But that may be too simplistic a view.
Just, Chris, if I could tease that out a wee bit further, then Chair, we'll end that. Have the police ever questioned or arrested this said person under harassment laws?
Not to my knowledge.
Would you both not think that would be appropriate? That's just the thing that springs to my mind.
If someone is a repeat offender, ultimately there will have to be some sanction at some point. So we're not saying that there shouldn't be. If someone is aggressively begging and harassing customers and staff, then ultimately there will have to be some sanction. Or so I think the views of the police in terms of what practically suits them. I think the problem that you there have is there isn't enough neighbourhood police even to respond to this. As you know, committee members know that we surveyed our members in this, and the follow-up with the police is hugely problematical now because they just do not have the numbers on the ground. So I think it is about the public space protection orders. There's also a situation where there's a gap in the legislation to deal with on-street drinking. So, the police can do nothing about it. They can't confiscate or seize the alcohol when that problem is there. Again, that's another area. So I think there are lots of things that can be done both in legislation but also in terms of giving the police more powers in certain areas to address this. So I think there are some practical solutions there that we could arrive at. But I think, as you said yourself, Patsy, to have a situation where the legislation is repealed and nothing is put in its place, is not the best way forward. So that's why we've said that it's about replace rather than repeal.
Okay, thank you very much both for that. Thank you, Chair.
Deirdre?
Thanks very much. And obviously, I know Chris as well as in my constituency. And I suppose the first point is, like, nobody should be intimidated or threatened in their place of work. It doesn't matter who it is, and that goes without saying. At the same time too, though, I mean, this is Charles Dickens era legislation. It's draconian, and it does criminalise some of the most vulnerable within our communities, and I know you've already said that, and it is outdated, and it does need repealed in its current form. And I suppose the thing for us, I mean, we want to deal with the issues and the concerns that retailers, but even communities, and I suppose that's the thing for me, Glyn, even in terms of what they're doing in the south. You're pushing it on just up the street. So we're not actually dealing with it, we're just pushing it on. And I think we do need to take a more rounded approach to this. So it's just, I mean, and I don't know if vagrancy legislation is the right way to do that either, to be honest, that you're going to replace it, but it's a form of vagrancy legislation. And I think we need to look at other areas, and are there gaps in other areas, and it'll be keen, I suppose that's why maybe Patsy's asking you, have you got examples of how we could look at this? Obviously we're going to have the PSNI in, and we have been asking them before, are there other pieces of legislation? Because I would agree with Patsy on the stuff you're saying, Chris. I mean, that is like harassment, why there's not an exclusion zone or something then if that is a certain type of behaviour. But that's of that individual. That's not everybody that's homeless or that's finding themselves begging, do you know. So there are different issues, and obviously there are those that are violent, and of course the law needs to protect people that are on the receiving end of that. But is it through the vagrancy that can be done or should be done? Now, I recognise in repealing it there's a gap, but I suppose I would ask, is it even being implemented anyway? So there's already a gap if the current legislation is not being utilised anyway. And I suppose for us it's just trying to see, because I mean, I completely empathise. I don't think anybody, you know, local residents shouldn't be intimidated or treated like this either, and neither should shop workers, who are some of our lowest paid workers, you know, generally anyway, in terms of the economy overall. So it's just what alternative and what protections we could, and I suppose I'm keen even to hear that. I know you have touched on the settings and stuff that's going to be coming forward, Glyn, as well. But are there other areas, you know, that you have identified that we could be raising with both the police and the department to ensure then that we are reducing that? But also, obviously, I mean, we've been trying to do work as well with health and justice, as you say, to make sure there's no breakdown, and there is. It's still a very siloed system. And, you know, for me, even in terms of the sleeping issue, the housing first approach, for me, should be the way, and I know there was work done on that, and it hasn't been done since, where health, communities department and justice should be working together, actually providing accommodation with that wraparound support, so that individuals are being supported, not just in a home and it's taking them off the street, but if it is addiction support or mental health support or trauma support, that they're actually getting that within the home. And I know the Simon community are going to be up next. You know, they have used financial transactions capital, for example, to purchase new homes in the likes of East Belfast. So are there gaps there that we need to make sure? Because even if we kept this legislation, these problems are going to continue unless we do some of the preventative work. And of course, if there is a police and our community safety response by way of legislation that we need to look at, then more than happy to do it. So I would just be keen, and we're not expecting you to have all of this now, you know, but as we are moving through this and looking at other pieces of legislation, just to keep the dialogue with yourselves going. Because obviously, I mean, I would say everybody's keen on, you know, we do want to protect and make sure workers feel safe, and that the community feels safe, and those with vulnerabilities feel safe as well, and get the support that they need. I just don't know if it's through the vagrancy stuff, because I think some issues are being conflated, but as I do understand that there is a gap then that will be created, and you know, what do we do in the meantime? And I don't know, maybe if it is at some point, because we had done this before, a joint meeting between health and justice, and it could even be a tripartite meeting with communities as well, to look at these issues in terms of the prevention and intervention work as well, and ensuring that the departments are working in a more collaborative way. You know, so why isn't the Housing First programme, you know, being driven forward? Where is it? Is there that cross-departmental collaboration, that if there are people that are vulnerable or potentially violent with vulnerabilities as well, that, you know, there is that focus of approach to try and prevent it and to prevent workers feeling intimidated. So it may be worth, Chair, at some point looking at that. But I'd be keen, I know you mentioned the retail staff and the attacks. Are there other areas, or even if you can, I suppose, write to us afterwards if you have identified other areas or gaps of work?
Well,
Not even within this legislation or this current bill, but obviously with the 2 future bills, you know, one on victims of crime is going to be the last bill, and then obviously the sentencing one we're due to have here either before Christmas or shortly after Christmas as well.
Well, maybe in 2025 you wouldn't call it vagrancy legislation, but I think, you know, there does need to be some statutory and legal provision in the Justice Bill that covers some of this area. Maybe I wouldn't call it vagrancy. In fact, the vagrancy bill predates Charles Dickens. It's so old. You know, it was for a completely different era, a different world entirely. It has to be a co-design effort between all those different agencies, business and the PSNI. And I think, you know, there were several different working groups that have been set up in the city centre. But again, what's very clear from those statutory agencies, they've had their budgets cut. A lot of the provision to help the homeless in the Belfast city centre is charities who are themselves facing so many pressures as well. So I think it is about that co-design piece. And I think that's a good idea, bringing together those 3 committees or 3 ministers to get round the table and say, look, how can we move this situation on? I think the sentencing bill, that's critical, to have the assault of retail staff put in as a statutory offence alongside other, you've got emergency services, first responders in there as well. We also need to look at, you know, the fines for shoplifting. I don't think they are fit for purpose. We have suggested that, you know, a starting point over that there's a £1,000 fine for shoplifting. We really need to push that because there's a perception there that shoplifting is not a real offence, that's a victimless crime, where independent retailers like Chris have shoplifting every day. That really, really pushes them, their small margins, to be even smaller. So I think, whilst yes, I'm absolutely agreed there needs to be a multi-agency approach, but we also need a zero tolerance approach to shoplifting, to antisocial behaviour, to assault of shop staff. I mean, part of my job is looking at members' CCTV. And when you see young, vulnerable shop staff facing dreadful assaults, it is absolutely shocking. And we've got to make sure that we adopt a zero tolerance approach to all of that. And, you know, it does mean in terms that there are ultimately, at the end of the day, significant sanctions if people do break the law, whether it's shoplifting, assaulting shop staff, antisocial behaviour, all of those things. And there is a thing that, you know, who made the decision to locate so many hostels at one place? I mean, again, you've got to look at that. That's, again, I would suspect Department of Communities will ultimately have a big role in that.
Or cookies or off licenses, or...
Yeah, absolutely. So there's a lot of, as I said at the start, there's a lot of moving parts in this, and there's a lot of things we could write. And I think if we have that partnership approach, and again, you know, the last Assembly mandate had the High Street Task Force, which was very effective in bringing together all the different government departments, councils, business, trade unions, voluntary sector, to agree a report. It's maybe something like that we need to be looking at again, for some form of task force to address all of these problems, and to make sure all the right ministers, agencies, businesses, trade unions, voluntary sector are at the table, and we focus on what solutions are there, and ask ourselves what success looked like ultimately.
Okay, Morris Brolly.
Thank you very much, Chair. Thanks very much for the presentation. There's been some very good questions from other members there, and some answers to some of the things I was going to talk about, but it's very, very interesting. But do you see any benefits in terms of moving towards a more supportive base rather than punitive approach to homelessness and street begging? And you have already touched upon assaults on staff and shoplifting, but do you think addressing vagrancy would increase footfall and customer safety, staff safety, or well-being throughout the premises? And have you had any discussions with the business investment group to tackle town and city centre locations for not just vagrancy, not just homelessness, but also the increasing problem of, I think, threatening assembly or assembly leading to harassment or antisocial behaviour. Have you had any discussions specifically on those new detrimental signs that are coming into the shopping areas?
Just if I get the picture, if I get the picture of your question right, I think to respond, both business improvement districts in Belfast City Centre responded to the consultation. I think there was maybe 9 or 10 respondents, and 2 from business were the 2 bids, and I think they're echoing the sentiments that we would be talking about around the table. Again, I go back to what I said previously. It's quite simplistic for me. It's layman's terms for the business environment that I operate in, and it just my ask is, can we do something that makes the situation a little bit better? And taking a standoff approach doesn't feel right. Do you want to be totally punitive in your approach? No, because I get the sense that comes across as a little bit draconian. But can you be totally standoffish? No, I don't think so. I really don't.
And I think it's a given that, you know, our high streets need to be safe, inclusive, shared spaces. You know, people need to have confidence they can shop and socialise and feel safe. So that's why we're working very heavily with the PSNI and Operation Seasons Greetings that will be launched very, very soon. And because we've got to ensure, particularly in the run-up to Christmas, there's a lot more people in our high streets, that they are safe and can get home safely as well. And not forgetting as well, shop staff. I mean, one of the big challenges that we face this time of year, where shop staff are under huge pressure, is asking customers to be respectful to shop staff who are under great pressure to make sure everybody gets the products, the presents, and have a good time this Christmas.
Yeah, but I really wanted to expand that business investment district to across Northern Ireland as opposed to the cities. The problems that are manifesting in Belfast and Londonderry are just as relevant in rural areas as well. But to address the last point I made there, do you think legislation should be included for threatening assembly or assembly leading to harassment or antisocial behaviour? Do you think that should be included?
Well, we need to ensure that, as I said, the police have the right tools to do the job. So yes, I think that obviously is part and parcel of it. Just in terms of business improvement districts, we helped draw up that legislation 15 years ago. I think you have just 9 or 10 business improvement districts. You have 3 in Belfast City Centre. They're a fairly good model, and obviously I think that we not only have we been champions of the business improvement districts, we've also been doing a lot of work to revitalise the chamber network throughout Northern Ireland, because there are still towns that we have that don't have chambers of commerce or traders groups. I think they are important as well, both in engaging with the councils, but also more importantly engaging with the PCSPs, with the police as well. So yes, there's more work we need to do on that front.
I do think the bringing legislation in around the threatening piece around assembly, if I get you right, if I take that out, if you're let's say you're a shopkeeper who's maybe not from our lands, who's chosen to come here and set up and make your own, make your way by setting up your own business, if they're not protected, then yes, you probably should be including that. You probably should be including that in your legislation.
Yeah, but I was thinking generally, no matter what someone's background is, if they have a shop and there's groups assembled outside for whatever reason, young people, adults, whatever, I think the shopkeepers and the staff and the shoppers themselves, the customers, need protection of some sort, and the police need to be able to move in and move people on.
I would agree. I have had a sample of that, and we tend to get that. We tend to get that over the summer holidays on the Armour Road when the kids are out from school, and it gets to a little bit later on, and you get a group of challenging adolescents who continually return to the shop. They Quite recently we had the police involved this summer because a number of the individuals were coming in to shoplift eggs, and they were climbing on the roof of our shops, and they were dispersing eggs over the front of our shop from the roof onto the oncoming traffic on the Ormer Road. So yes, if you had the power to get in at source at that and maybe break it down and move the kids on before it gets to the point where they're actually doing something that can be perceived as being totally criminal, yes, it would be helpful. And I've had many a summer of that coming about.
Okay, Morris.
Thank you very much. Thank you.
Okay, Ciara.
Yes, thank you.
Thank you, Glyn and Chris, and I don't want to go over old ground, particularly what my colleague has mentioned, and obviously it is intolerable for retail workers and the likes of yourself and business owners to be subject to the range of issues and findings from the report, and I did read through that report, and I do welcome obviously the legislation forthcoming in the sentencing bill. However, I think we all want the same thing. We need to protect yourselves and the workers, but likewise we need to protect and support the most vulnerable and have a compassionate approach to that. So I think we all want the same thing, and it's a balancing act in how we go about it, and it is about interagency work. And I think, Glyn, you have mentioned a range of areas and issues that are complex and need resourced, but I'm conscious it's not going to change overnight, and it's about taking a proactive approach. So what I would like to ask is maybe what proactive approaches RetailNI and the business sector taken to bring in collaborative agencies around the table to support each other, because I know we done it in Derry a year ago, and we brought business, etc. Now it's about building relationships, it's about building trust, it's about understanding the resources that are available and doing the best with what we can, but likewise then advocating for the additional resources that we need, whether that is our supporting people organisations, whether that's our hostels, whether that's our neighbourhood policing team who are trying to do their best. But to be honest, if anything happens in the city, the neighbourhood policing team disappears because they're resourced into more pressing areas, even though they're trying to build up relationships with the most vulnerable and have been doing a good job. So there's willing partners, I think, in our cities and in our towns collectively are coming together, but it needs resource and supported. So I'd just be interested to see what plans RetailNI have to try maybe to support that enabling of organisations coming together to support stuff, whilst also looking at the legislative side of things.
What we're doing is, you probably were included in our submission, we did a comprehensive survey of our members about their experiences of shoplifting, antisocial behaviour, all of it, so that's in there. And following that, we've engaged with PCSPs, Chief Constable, all the different agencies, the policing board. And what struck us, particularly on the PCSP front, is how few of our members actually knew what a PCSP was. Again, there's a lot of work there. I think there's proposals to change and restructure the policing board. Equally, the PCSP, there's very few business people on PCSPs. So we've done the hard yards in terms of all those different agencies. We're talking to the police on an almost daily basis, and so we're open to obviously going further and faster at how we can reach out to those other agencies, and we've I think we are making slow progress, but I mean we need to up the scale of that progress, and likewise we're on the same page as the Chief Constable to make sure the PSNI gets a proper financial settlement. You talked rightly about neighbourhood police officers. They are the frontline troops, so to speak, in terms of this battle. We need to have more neighbourhood police. I think there's hundreds less now than there was. I think the second thing is we need to make sure that, for instance, retail and business crime generally, if you look at the policing plan that the policing board produces, it barely gets a mention. So we need to make sure that all the different agencies, even within that whole criminal justice, Department of Justice orbit, that they themselves have clear recognition of the problems, the challenges, and what solutions are to this problem. So we have been spending the last 2 years, I suppose, not educating some of these bodies, but we've talked to the PCSPs, have their own sort of get together. Chris and I went and presented with them, and I have to say their levels of knowledge and understanding of the pressures that retailers and other businesses on the high street face with crime, there's a lot of work to be done there.
Just on that, because you're very much fixated, to be honest, on policing. Where is the community side? Where is our homeless organisation side? Because they're doing vital work and they're supporting the most vulnerable with a lack of resources. So where has the business sector helped maybe to enable and support them? Because it really is, we collectively, these vulnerable people, and I don't want to conflate those that are homeless and vulnerable to other areas of crime, which is totally separate to this vagrancy aspect. So we just need to be really careful. But those in regarding this vagrancy, we're talking about homeless people, people that are begging, that are the most vulnerable, where they could be my brother, my sister, your mother, your father, based on circumstances. They're people that live in your neighbourhood. They're part of that community. So it's about a community collective response. So where is the business? And I know businesses are busy like everybody else, and that's not necessarily your primary remit, but it is about everybody going the extra mile and working collectively together, particularly around homelessness, and those that have to go out and beg in the street or under coercive control or begging. So what has been the role of businesses to date in liaison with the community organisations, the homeless organisations, the hostel organisations, and supporting them to support the most vulnerable, as well as the ongoing work that you're doing with the police and the neighbourhood policing team? Because if you speak to the neighbourhood policing team, they'll tell you their job cannot be done without the support of our hostels, our supporting people programmes, etc.
Well, I think first and foremost, it's not a fixation on policing, because there's no sole policing. It always is a partnership between business, general public, police, community organisations, statutory agencies. That's why we've said at the very start of this presentation is this needs to be co-design efforts to meet this challenge. You asked us as a trade association what we're doing. I would put that right back to yourselves. What is the Department of Justice, the Department of Communities, all the other departments, what are they doing to address this? And it's whilst we will meet and engage with as many different organisations as we can to deal with this challenge, ultimately, it is up to ministers to bring forward those key players and to agree a strategy. And I think to date that hasn't happened in any meaningful or sustainable way. So one of the suggestions that we had is, again, recall the High Street Task Force. It brought together 6-7 government departments, business, trade unions, voluntary sector. Now, admittedly, the whole issue about crime and antisocial behaviour, it was part of it. It was obviously looking at much beyond other challenges facing the high streets. But again, the current executive refused to recall the High Street Task Force, which I can't understand why, because that was a body that brought together all those different bodies, agencies, call it what you like. So I think, yes, we do need to have some vehicle that brings together all the respective agencies, better communication. There's the sensing piece as well. It's in there as well. So we're absolutely up for that approach, but we can't bring those agencies around the table. That's why we have ministers to do that, and I think that's why we need to see ministers step up to the plate and start getting that round table approach, because we can't solve this alone as purely policing problem. It can only be solved in that multidisciplinary, multi-department, multi-agency approach.
I definitely agree with you at that higher strategic level. And obviously I just came from a meeting here where you had the Department of Health and the Department of Communities strategically working in relation to addressing homelessness. So there is strategic work being done cross-departmentally. It could be resourced better. It needs way more investment. There is ongoing work at the strategic level, but I was more focused at that community level. Your local community business, and it's working in the local community, and I know it's quite difficult. Just is there a way of is there a vehicle locally in your local community that comes together to be able to address the ongoing issues that you've mentioned, Chris?
No,
is that
no.
being driven?
At a time coming out of COVID, I endeavoured to set up a business organisation on the Ormer Road, but unfortunately once the crisis of COVID dissipated, so did all my members, or potential members, as we were getting to a point where we're bringing a constitution together because they were distracted with the runs of their own business. From a community interaction point of view, I support my local soccer club, my local GAA club, the local band hall, the local community group, which would be Open Ormo. My door's continually open to that. I'm I'm trying to run 5 small businesses that are being squeezed at every angle, creating employment for for just over 100 people and £1.4 million payroll, and all the benefits that we pay back into the centre through taxation and whatever else. I didn't expect to be asked that question today, to be honest. I didn't expect to be massively in solution mode here. I was coming here, yes, as in my capacity as vice chair, but also as a business operator who's saying I need help because this problem continues to rise. Shoplifting continues to rise. People being difficult around premises is getting bigger and bigger and bigger. So I come with a bit of a simple man approach and saying I need a little bit of help, and I didn't expect to be asked to provide a solution beyond a solution to my immediate problems. What goes beyond that, I wouldn't have even thought to think I would need to have given an answer to that today.
I suppose we all want solutions to the issues that you're dealing with, because it is unacceptable.
Yeah.
And it is at a strategic level, it's wider, and we know it's not going to be short term, whilst your retail workers are dealing with this on a daily basis and you as a business. So we're trying, the ideal is doing both, having that community-led approach that can assist, and that's not on retail, that's on a wider all community coming collectively together to support the most vulnerable when it comes to homelessness. The wider issue then on a daily basis of what you're dealing with at strategic level, that's your interagency and that cross-departmental work that is, as you say, bitty at this moment in time. So it's a wider issue as well that needs to happen, but it's something we all want to see, is that cross-departmental working at a strategic level to support the likes of yourself and local people in a community. But it's quite difficult, so unfortunately we have to look at both if we don't have a solution and a quick solution for you. So
well, to the chair, Ciara, what I would say is that we were the first trade body to produce a wellbeing plan for our members and their staff. We launched here in 2022. We were the first business group to do that. We absolutely get the challenges around mental health and our role to play. Things like, again, we flagged up to the Department of Health, things like an obesity strategy. We need to be part of that conversation. And there is a perception within the various silos that make up government here, is that, you know, that a lot of those issues, business is the last person they actually speak to. So a lot of it is in the system that is there. And I think, you know, business is not just what Cathy Archibald is doing. Business has a role in every single government department. And we're up for those conversations. We're up for that engagement. But at times, we're not invited to the table to input in this. But if we are being as proactive as we can as a trade body, and, you know, we've produced surveys, we've produced plans, we've produced detailed reports, detailed submission to the programme for government. We're up for all of those things. But I think the onus is the executive generally on issues like this to work smarter and work more on a collaborative basis.
Okay, Brian, you want to indicate it to come in. I'm going to press you on a brief question and a brief response.
Brief and a brief response. Just interested, Chris, what you were saying earlier. Have you, from your experience, or Glyn, noticed a difference in when problems have arisen, a difference in the sort of statutory response, either in the city centre compared to like the Ormer Road, you know, like an out of city centre retail hub? Would you have felt there's less support in one than the other, or is it similar?
My neighbourhood retail officer was in Mace Ormer Road yesterday. It'd be the first time I've seen him in 2 years. So
there's more support, you think, in the city centre?
My worry would be is
I'm not saying there isn't.
My worry would be is the intensification of support in the city centre. It displaces.
Not to forget about the other
arterial routes. Yeah, I mean, yeah, but when you.
And would there be rough sleeping?
No,
rough sleeping's more in the city centre.
No, what I would see, and this is maybe the nub of some of the problem, or maybe some of the what can end up being someone presenting as possibly being, and I think that's in maybe being able to unpick some of it when they, you know, when police do get involved. Like a lot of the individuals who appear on the Ormer Road, I don't believe any of them are homeless. I believe they're
That's
to feed the addiction that they have, truthfully, rather than the addiction means they can't hold down work, so they're out doing.
I think that's
Yeah.
we need to be really, really clear.
Yeah.
This is about vagrancy and homelessness.
Yeah.
And then the wider issue of individuals.
Sorry, that probably opens up, that probably unpicks it really, really, really well. You know, if you have, you know, if you have someone who's struggling, you're a business operator, and you know they genuinely need help, you provide help to them. We've got to the situation that we have, and many of the city centre retailers have got the situation that we have, is that the individuals that they may be tackling or maybe presenting, but they're not exactly. It's actually the addiction that's driving the activity that they're involved in, be that shoplifting or assault or dwelling for income, and that's really, for me, getting under the skin of that. If I came in the morning and someone was unfortunate enough to be sleeping in the front door of my shop, I am going to step over that individual and not make them feel welcome. There's a coffee machine getting turned on in there, and they're going to get a cup of coffee, and we'll be putting hot food on. They're probably getting something to eat and whatever else. But it's when that then turns into someone who will stay at the front of your premises, relentless, and will not move on, and will create. If they have a complex life, they can create complex problems in a business environment. That's probably the nicest way to say that. Okay, thank you very much for your time and your presentation. The next item is on the same subject, so you're very welcome to stay in the room if you so wish. But thank you very much for your time and your presentation. Thank you. Okay, folks, agenda item number 5 then is Justice Bill Repeal of Vagrancy Legislation Amendment, Homeless Connect and Simon Community Oral Evidence Session. Can I refer members to pages 32 to 53 of the meeting pack for the relevant papers? Can I inform members that today the committee is receiving oral evidence from Homeless Connect and the same community on the planned departmental amendment on the repeal of vagrancy legislation? Can I welcome Mark Baillie, Head of Policy and Programmes, Homeless Connect, and Cathy Brolly, Public Affairs and Policy Manager, Simon Community. You're very welcome to the committee. Can I just warn members? So Mark and Cathy has been in the room the whole time, so they have heard, like me, and suffered, like me, your opinions. So if we can, keep it to questions, please.
Not speeches.
Yeah.
And then not speeches, not opinions, just questions, and then we'll get through this more succinct and with better quality evidence. I'm not looking at anybody else. I'm not looking at anybody particular.
You're looking in the mirror.
So can I invite Mark and Cathy to give an opening presentation? Thank you.
I'm going to open and then Cathy will follow me afterwards. So yes, thank you for the opportunity to present to the committee this afternoon. I'm hoping that you won't want to break my other arm after I make my remarks here. So hopefully you've had the opportunity to read our submission in advance. And I'm going to give a brief overview of our position before handing over to Cathy. So, as the representative body for the homelessness sector in Northern Ireland, Homeless Connect regularly engage with our member organisations on policy matters which impact them and the people they work so hard to support. And our submission to this consultation, which both to the committee and to the department, was informed by engagement with our policy forum, which is made up of representatives of our member organisations who day in, day out work so hard to support people at risk of or experiencing homelessness here. And as a principle, we believe that it's also critically important to engage directly with people who have lived experience of homelessness on matters of policy which affect them. And for this consultation, we held a focus group with a group of 8 individuals who were either currently experiencing homelessness or have in the past experienced homelessness, and that included rough sleeping as well as experience in hostel accommodation. And we are incredibly grateful to them for their insights on this issue. So to briefly summarise our position, Homeless Connect supports the Department's proposal to repeal the provisions of the Vagrancy Acts on rough sleeping and begging. We have publicly commended the Minister for Justice for bringing forward these proposals. There's nothing wrong per se with old legislation if it's effective and it's fit for purpose. In this case, the legislation currently in place, in our estimation, is not fit for purpose and is contributing to the stigmatisation of people experiencing chronic homelessness in this society. A crucial point, and I really want to emphasise this from some of the debate that we've had earlier and in earlier parts of the discussion on this, which our policy forum and our lived experience group really strongly stressed to us, is the importance of differentiating between rough sleeping and begging. These two activities are often elided together as if they always come as a package. They don't. That the reality is they simply don't. And many people who sleep rough do not engage in begging, and vice versa. Okay. And as to the, I mean, again, your predecessor as chair made this point very clearly early on in the discussion on this, that those are two separate issues, and I think it's really important that they are kept as separate issues. So I'm now going to consider the two issues in turn. Okay. Firstly, rough sleeping. We want to commend the PSNI for the decision they made several years ago now to look not to look to arrest or prosecute individuals who are sleeping rough under the Vagrancy Act provisions. We have met and heard testimony from people who have been sleeping rough, who were signposted by the PSNI to relevant services. That was a very different response than they might have met in decades past, and it was excellent to see. And the approach currently adopted by the PSNI is a compassionate one, which recognises that rough sleeping is a multifaceted and complex phenomenon which cannot be resolved through a criminal justice response. If the PSNI are not enforcing this element of the law, and that's been definitively illustrated, the PSNI have made that clear in evidence to you, the question might be asked, why should you use legislative time to remove these provisions from the statute book if they're not being used anyway? In our view, it remains important that these provisions are removed due to the stigma that is attached to rough sleeping arising from the fact that it's criminalised. The law is a teacher, and it signals what a society deems to be right or wrong, and the maintenance of this statute sends a signal that rough sleeping is worthy of punishment. And in our view, that needs to change. The theme of Homelessness Awareness Week 2025 is See the Person. And what I want to urge you today is to see the person that we're talking about here who are impacted by these statutes, to keep them at the forefront of your mind. People who are sleeping rough are amongst the most marginalised people who live here. And the vast majority of people in this situation have experienced massive levels of trauma in their lives. And a properly funded trauma-informed approach provided collaboratively by a range of organisations is much more likely to generate positive outcomes than a solely punitive response. And I'm going to leave it to Cathy to talk more about that in her contribution in a moment. I would further point out that some of the language utilised in the two statutes against individuals sleeping rough is just simply inappropriate, and it needs to be removed from the Northern Ireland statute book. Terms like rogues and vagabonds, which is in the statutes of the law of Northern Ireland today, simply needs to go. It's time, and it's right that they are removed from the statute book. Turning to begging, we agree with the view of the Minister that it is not appropriate to criminalise people who are simply begging, but who are not otherwise behaving in a way that would attract criminal sanction. That's our principled position. We listened with interest to the evidence session with Professor Brown, and we recognise the important issues that he raised. Neither Cathy nor myself are professional lawyers, and we would value the response of the Department of Justice, which no doubt you have already sought, on the points that he raised. Homeless Connect would point out that the consultation document indicates that the PSNI had stated that the only gap that would be created by repeal would be, and I quote, an inability to deal with simple begging through an out-of-court disposal or prosecution, end quote. And this was reaffirmed during an evidence session that this committee had in January of this year. If it transpired that that was not the case, we would of course consider further proposals that were brought forward. We do recognise that it's important for the PSNI to have the tools necessary to address disruptive behaviours which go beyond simple begging. But what we would point out is our full submission indicates it's not necessarily a straightforward thing to do, which I think you're already wrestling with now. Thank you, and I will hand over to Cathy.
Thank you, Mark.
Thanks, Mark, and thank you, committee, for the opportunity to speak today. As Northern Ireland's largest homelessness charity, Simon Community has a deep understanding of the traumas and experiences that can set people on a path to homelessness. Every day, our staff are on the front line of the mounting homelessness crisis and see firsthand the immense challenges people face when they lose their home, often through no fault of their own. As Mark mentioned, people who are experiencing homelessness, particularly those who are sleeping rough and engaging in street-based survival activities such as begging, are among some of the most marginalised people in Northern Ireland. And this has been clearly evidenced by our new research on adverse childhood experiences and homelessness, which was launched last month at a Stormont event kindly sponsored by committee member Ciara. And I've brought a few copies of the report with me and we'll leave them here for the committee members. But our research paints a clear and sombre picture of the realities of people experiencing homelessness. People living in homeless hostels and rough sleeping face significantly higher levels of trauma and disadvantage throughout their lives compared to the wider population. Almost all have experienced one adverse childhood experience, such as neglect or abuse, and 2/3 have experienced 4 or more. In comparison, in the general Northern Ireland population, less than 18% of people report 4 or more ACEs. 74% have a diagnosed mental health condition, almost 4 times higher than the general adult population in Northern Ireland, and over half have been admitted to hospital for a mental health issue at some point in their lives. 1 in 5 have been in care as children, and 62% first became homeless before the age of 26, and shockingly, around 1 in 5 first became homeless as a child or a teenager. In terms of rough sleeping and survival strategies such as begging, 64% have slept rough at some point, rising to nearly 9 in 10 among young men aged 18 to 26. And experts with living experience told us that rough sleeping was rarely a choice, and it was often linked to feelings of shame and not being able to ask for help. Around 1 in 5 reported taking part in begging, but they described this as part of an economy of survival, driven by a lack of safe options rather than individual failings. So this research clearly highlights that for many, homelessness is not rare or short-lived or a personal failure. It begins with childhood adversity and trauma, is exacerbated by underinvestment in mental health services, long waiting lists for addiction support and housing shortages, and it returns again and again in adulthood, marked by rough sleeping, repeated exclusion, and long periods without stability. In a society as compassionate as ours, is it really appropriate to criminalise people that often have experienced such significant adversity and trauma for simply trying to survive? And Simon Community think it is not. We strongly support the proposals to repeal what we believe are outdated provisions to criminalise rough sleeping and begging, because punitive laws not only fail to solve the problem, they can actually make it worse. They reinforce stigma, they push people further from help, and they draw vulnerable people into a criminal justice system that's simply not designed to meet their complex needs. Instead of the threat of punishment, people experiencing homelessness need support, housing, and compassion. And as illustrated in the consultation document and alluded to earlier today, there's already strong examples of what works. The Belfast Complex Lives Initiative, which Simon Community are involved in, shows that collaboration between statutory bodies and the charity sector can help people with the most entrenched needs access housing, healthcare, and addiction support, breaking that cycle of homelessness. My colleague who is involved in the initiative told me of a young man who was rough sleeping in Belfast, and through Complex Lives, we were able to find him a bed in one of our temporary accommodation services close to his family and support network. He started to engage with mental health support, and he now has his own tenancy and continues to rebuild his life. This example shows that collaborative, trauma-informed approaches that recognise the underlying factors that lead people to homelessness and rough sleeping work. So Simon Community believe that no one should be criminalised for not having a safe place to call home and for being failed by systems that should have protected them. We believe that repealing these provisions will help to remove stigma, they will encourage people to access support and engage with services, they will reduce distrust and remove fear of prosecution for simply trying to survive. Thank you for your time, and we look forward to discussing this with you further.
Thank you, Mark and Cathy. Thank you very much for your presentation. Can I ask a question then? Have you seen Professor Kevin Brown's proposed new provision of begging causing harassment, obstruction or public order concerns? I know that you had said about simply begging shouldn't be a criminal offence, but begging causing harassment, obstruction and public order concerns, should that be?
I haven't had the opportunity to see that paper yet. Of course, we'll be happy to look at it. As I said, our principal position is that simply begging should not be criminalised as the law currently does. We'd obviously consider provisions around harassment and other elements. Again, he was very eloquent in his evidence and would take very seriously what he's saying. And I would hope to hear the department's response as well, because we'd be interested to know what their thinking is on the matter.
Just for the detail, the constable may direct a person who is begging in any place or whom the constable reasonably believes to be acting or have acted in a manner that harasses, intimidates, assaults, threatens any person. It does go on to talk about obstruction and impeding, but then it also talks about a constable may direct a person who is begging at or near an entrance of a dwelling, vending machine, night safe, ATM machine, that type of thing. Would you I know in principle you want to see the repeal of this, the old provision, but are you open to a modernisation?
We're certainly open to considering it. Is what I would say. I mean, as a representative body, I can't on the fly give you an answer to that question. But again, I'm not rejecting out of hand either. I want to hear the views of our members and of our senior team. It's a valid suggestion, and we're not saying that some of the activities that are sometimes associated with begging should be subject to, if they are disruptive or causing antisocial behaviour. We understand there may need to be penalties in that situation, but we'd want to see. I'd need to consult before I could give you an answer on that.
And then there's also another option there of looking at an offence for trespassing with intent to commit criminal offence. Again, you'll not know the detail if you don't know, but does that sound something that may be required, or would you be totally opposed to it at this stage?
Again, open to considering it. I need to look at the detail of it.
Right. Can I ask you both, have you any evidence of any organisational begging with coercion, where the beggar is the victim of organised crime?
I'm not aware of any of those cases now. Again, there has been allegations around organised, particularly around trafficking, which I know you're familiar with. And again, I don't have any hard evidence of that. Again, other than rumour, and that's not particularly helpful to the committee.
Cathy, have you any evidence?
No, I've not heard that either from evidence.
Okay, Deirdre?
I know it's just on the back of the point Paul raises, so around if there is harassment or other types of activities which is a danger to other members of the public or indeed themselves, but do you still feel that should be attached to a begging element of legislation, or should that be picked up under a different piece of legislation that actually deals with the issue of harassment rather than trying to tag it on to the issue of begging?
Yeah, I mean, from almost Connect's point of view, but made it clear there, the Vagrancy Acts that their time has gone. I don't hear anyone defending the language of rogues and vagabonds and the other terminology that's used. I mean, again, yes, there's a question as to what the exact vehicle is, but no, I don't think it's under the ambit of Vagrancy Acts, and I don't see any other jurisdiction that's taken that approach either on these islands. When they've considered this issue.
I'm also keen then in terms of the engagement you've had with people with lived experience, because I think it's important, our legislation, what's the outcome of it, and does it actually, so what issues are they raising in terms of support or gaps to address some of those vulnerabilities, and even if that is, substance use issues and trauma relating to that that they would see. And I suppose if you have had any more on the housing first approach, and has that progressed in any way between the three departments?
Sure, I can only speak to so we have a group which is called Echoes of Home, is its name, and again the 8 folks took part. There's more than the 8 that are involved in it, but they took part in this particular consultation. The strength of feeling that was conveyed about the language in the Act, I couldn't convey it to you. Obviously the level of, again, people are internalising this, hearing that our law says that they are rogues and vagabonds for the experience that they've had. And again, the strength feeling I have about it is partly out of listening to what they've had to say and hearing their points of view. Again, there's something that you cannot, in terms of why lived experience is so important, is you can read tons of research, and Cathy and I do, but there is something about listening to the voice of people who've actually been through this experience. They can see and understand things that we can't, and it's important that we have the humility to listen to that. Again, our group, we've consulted them on a whole range of different issues, which has been hugely valuable to us. Again, I think the number one issue that we would constantly hear about is you cannot resolve homelessness without an adequate supply of affordable and social housing, and that is, that's a necessary condition. That would be a regular theme. But yes, I'll maybe stop there on the lived experience. In terms of Housing First, there's a significant report due to be published by the Housing Executive in coming weeks. I won't give any more on that, other than that's scheduled to happen. It's been in development for some time. We, as an organisation, strongly believe in the extension of Housing First. It is the gold standard evidenced approach to responding to chronic homelessness. And I know, Cathy, you, Simon Community, have a Housing First service.
Yes, we do. Yes, we have a Housing First for Youth service, which operates in 2 trusts, the Belfast Trust and, apologies, I can't remember the other trust, but I can find them out for you. But we know that it absolutely works. It's for children coming out of care, which our research shows often are very much failed and do end up in the homelessness system, which we believe is really unacceptable. And it just works. It helps those young people sustain their tenancies. The home is there for as long as they need it. There's wraparound support, because we recognise that homelessness is not just a housing issue. I think has raised a few times today. So we provide that wraparound support that really helps the young people sustain that tenancy. We've seen that it helps them feel more connected to their local communities, and also that it reduces those kind of risky behaviours that they might exhibit. So it absolutely works, as Mark said, and it's something that we very much want to see rolled out across Northern Ireland, because I think for the people who unfortunately are rough sleeping, that kind of approach will really work and help for those people.
To sustain the tenancy too, yeah, it's a critical bit. Yeah,
absolutely.
Thank you. Thanks, Chair.
Okay, Brian.
Thank you, Chair. Thank you for your attendance in your paper, and apologies I didn't make the APG meeting at lunchtime today. For some reason I didn't get it in my diary, so
apologies for that.
no, my apologies. Reading your paper, your position seems to be that you feel the vagrancy and begging should be repealed and nothing added at this stage, but carry out a review further down the line. So you'd have heard our evidence earlier, which I won't repeat, as the Chair pointed out. I have strong concerns, the police have concerns, have articulated that to me, that there is the need to have further tools in their available to them to control problematic behaviour. So, and I accept entirely not everyone who's homeless is either sleeping rough or is causing undue nuisance, you can put it that way, or harassment to others. So, am I correct in summarising your position that you don't think any other legislation is required at this time, or is there other legislation, could I push you, that you think, if a review was happening, is there other legislation which you would be considering or would be suggesting is looked at?
So in terms of, again, I would want to consider the 2 issues separately, rough sleeping and begging. Mm-hmm. In terms of rough sleeping, the criminal law is not being utilised as at the moment. It hasn't been for several years.
Yeah, no, accept that.
You know, so if we set aside,
you can't arrest your way out of the problem.
Precisely right. So turning to begging, again, when we looked at the original consultation document, and I read out the part where the PSNI had indicated to the department, now you'll obviously get the chance to ask them this, which is completely fair. They said that the only element that they wouldn't be able to prosecute was simple begging. They couldn't deal with an out of court or in a disposal. Sorry, I've got the language of that wrong, but that was the gist of it. If that was the case, that would be, if that is accurate, we don't believe any additional legislation is necessary. If it transpired that wasn't accurate, we would consider further proposals, such as Professor Brown had put forward. I'd obviously need to speak to our members about that to consider the detail of it. But I'm not I'm not just ruling it out straight off the bat. The question really is the legislation that exists in other areas sufficient to address the issues that are being raised, or are they not? And that's something you'll have to tease out with the PSNI and with the department. I know the department's position seems to be quite clear, that they think that the current statutes in place cover this, but Professor Brown's evidence suggests otherwise. We need to see the 2 sides of the evidence of that before we assess that. We do accept that there is a need for the tools in the arsenal for the PSNI in some of those cases where it goes beyond simple begging. We understand that. Mm-hmm. So it's simple. We're talking about a narrow activity, and if you read our submission, you'll see a summary of the discussion our lived experience group had, which actually gives a very good sense of the challenge about this issue, because what part of their discussion was to do with what constituted aggressive begging. And actually, when you get into the detail of that, it's quite challenging. So some members of the group said, if the person spoke to me in any way, that's aggressive begging. Others were like, no, that's not aggressive begging, it requires touch. So again, this was the kind of summary of the challenge. That's what I mean. It's not straightforward. Does that mean it's impossible? No, not necessarily. I'm just saying that there are complexities around these issues. That's as much as up. So hopefully that answers your question to some degree. Anyway.
Yes, no, I appreciate that. I mean, because our role here is not to talk about just ways of dealing with issues, but talk about legislation, which is what we're preparing, and what should be in legislation. So no, I accept what you're saying, or I appreciate what you're saying there, that you can see the potential for some strengthening around aggressive begging, which is causing nuisance or harassment or intimidation. That's not putting words in your mouth. And in terms of rough sleeping, and my attitude is always that it should be discouraged. And I think there should be sufficient support, and in many cases there are beds available, and I'm just aware that people, for a variety of reasons, are sleeping rough by choice, and I don't mean that flippantly, but there are hostel spaces available. But in terms of protecting, especially like city centres and retail hubs, as we were talking about earlier. Again, would you have any thoughts on that in terms of legislation? I mean, this has been suggested about public space protection orders, particularly for important spaces like city centre retail and arterial retail hubs.
I think so. In terms of the point about choice, our submission has some commentary about that particular issue. It's complicated, So if a person is allocated
all the complexity.
Yeah. I mean, if a person who's been in hostel accommodation maybe had a terrible experience, and then there may be a space in that hostel accommodation, and they're offered it, and they make a judgment, they assess what's going to do me less harm. They might be wrong in their judgment, by the way, but they are making that assessment. Is that choice? Is that somebody really choosing that option? I suppose the question around the public spaces protection orders are, again, will criminal penalties, is that the best way to handle this? And again, I think it was well put earlier by the member for Foyle around the need for balance in this. Again, we would be open to considering proposals. I am aware of concerns being raised about the use of public space protection orders because of the massive inconsistency across England in terms of their use. So some council areas where they would be using a very much a compassionate, complex lifestyle type approach, and then in others where they're much more going down the line of we're going to use public space protection orders against people who are sleeping rough. And again, so there's nuances in that. It's not. And again, I'm not saying we'd always have to consider the detail of the proposal, and I'm not in a position to give a definitive, because again, we need to listen to our members about the details about this. We are open to considering proposals, and I'm not denying the very real issues, some of which we heard earlier from the representatives. I mean, there clearly are very real issues. I suppose the question is, are criminal penalties the best way to address those, or is that merely addressing the symptom rather than the core of the problem itself?
Yeah. I suppose my final thought is it's just so at least the police, it's not necessarily about arresting people, but at least people knowing, not being in a position to say to the police, there's nothing you can do about this, and that people knowing, well, the police do have powers available to them, to coerce,
I think that's a fair point. Again, you need to consider what exactly that looked like. But at the moment, when it comes to rough sleeping, that threat's there, but it's not. They don't use it. And again, I think it would cause a massive outcry if they attempted to.
I think yes, that would almost negate the police using the powers, because it would say the established practice is this law no longer is used. Okay, thank you, Chair.
Okay, Patsy.
Thanks very much. I'm conscious too that we mentioned hostels here, and I'm very conscious, having dealt with constituents, that there are people who have to move to hostels that maybe been made homeless. There's maybe children involved and all that sort of thing, which can be heartbreaking in some instances, even where families are split up. Can you tell me, or can you give me an insight? Because it's not inconceivable that a person who's given abuse and harassing people, including employees of a shop, is doing the exact same thing down the road in the hostel that he may be resident in. And I'm conscious too that we have a duty of care to look after those people, especially children and the likes, who have been uprooted in many instances from their homes and schools and friends, often far away from possibly a hostel in Belfast. Can you tell me, or give me an insight, A, how a hostel might deal with that, and B, if there is any further legislation to strengthen that we should be looking at too?
Have a go then.
I can speak from our perspective anyway. I can't think of any specific examples where that has happened, but I know that we would take, at Simon Community, we would take that very, very seriously, because of utmost importance to us is the safety of the people who are in our hostels, and also the wider community as well. So if in cases that did happen, we would never give up on people. We always want to try and find the right setting for the right person, and in some cases it may be that setting is just not the right place for them. Perhaps they clash with other people, as people living together often can do. So we would always try and move them to another service to try and find a more suitable setting for them. That example that I gave earlier of that young man in Complex Lives, before he was moved to the service near his home, he was in another service. Now I don't think he was violent or anything, but I think there was just a clash there. It wasn't the right service for him, so we moved him to another service that was local to his family, and that then worked for him because he had a support network around him. So we would always take that very, very seriously, and we would just try and move the person and find the right setting for them.
Can I just add to that, the point about Complex Lives? I was asking the team at Complex Lives before this how many individuals they've supported into tenancies out of sleeping rough or being in chronic homelessness, and the number was 54 in a couple of years. And actually that's an incredibly impressive result, considering the number of the kind of the range of issues that folks in this position face. And again, what I would say is what that shows is that there are ways of supporting people into accommodation where you have accommodation, where you have proper funding for services. So Complex Lives has been a really effective multi-agency approach. It's not a silver bullet, it doesn't solve all homelessness, it's not going to solve all chronic homelessness either, but it's a very helpful approach in Belfast and other areas, particularly Derry, Londonderry should be considering, whether that's the right option for them as well. That's the sort of thing that we would be recommending.
So you don't see an opportunity there for taking up or new legislation to protect vulnerable people or people being subject to an intensified form of harassment or menacing behaviour, whether that be up the street, outside the shop, where there's young people coming in to work usually, or down the street at some of the premises that you would know much, much better than I, where there are other vulnerable adults, and indeed children who are going through rough enough times with their families as well. No?
And there's obviously with hostels, there's a real range of hostels, very different experiences in some of them, and there are challenges, I'm not going to deny that. In hostels, there's issues around staffing in particular because of underfunding of the homelessness sector here for many years, albeit that we are where we are. Again, I wouldn't want to suggest that hostels are somehow this unique environment where people are. That's the only example where you might see someone have challenges with violence. Or
I'm not
like
suggesting that. It's just it came up in the earlier conversation you were here for. So,
I don't think there's a need for specific offences around anything that's going on in hostels. I certainly don't see any need for that. That would be my.
I don't mean specific to hostels. What I mean is, if you're harmonising law for up the street, it should equally be applicable down the street, no matter where down the street is, outside somebody's house or at one of the hostels that are there for a very bona fide reason.
Obviously, there should be consistency in the application of law on these. So if there was to be a change, we'd obviously have to consider what the effect would be. But I would agree with consistency if that's what you're driving at.
Yes, that's it.
Yeah. Okay.
Okay. Thank you.
All right. Thank you, Patsy.
Thanks, Chair.
Well, thank you, and I'm conscious of our chair. We have to be succinct, so I'm just going to go with two questions. How do you both feel that we can balance that element of compassion, obviously, with community concerns that were raised by the likes of RetailNI, whilst I am conscious RetailNI reporting the concerns they raised, they should not be and are not equated to solely those that are sleeping rough or begging, which I think Chris, the retailer, has highlighted the ongoing support that he would give to someone that is vulnerable. So just that area, how do you feel we can balance that currently? And then secondly, and this is a hard one, if the committee could make one recommendation to strengthen the response to homelessness, what in your view should that be?
Yes, I think as was said earlier today, I think everyone in the room, even kind of previous witnesses, we all want the same thing. We all want to end homelessness, and we don't want anyone to be forced to sleep rough or be forced to beg to kind of get by. And I think it was Connie Egan raised earlier is that perhaps the current framework isn't actually working. Like criminalisation, I don't think, or the threat of criminalisation will not maybe help us get to that. and actually it just moves people further away from the kind of support that they need. You know, having that additional stigma of having potentially a criminal record, that just creates even further barriers to housing, to employment, to the support that is needed to get that person out of homelessness, to end homelessness for that person. So I think, as we've talked about, for us it really comes down to Complex Lives Works, that multi-agency kind of collaborative approach, really as far upstream as possible, because I think that's where we really need to start looking at. Like, we know there's so many issues that many of the people who are sleeping on the streets, there's been so many challenges and traumas within their life, so many engagements with public services that we believe are often missed opportunities to identify that person and actually try and break that cycle for them. So I think that multi-agency, everyone having a role to play to try and break that cycle of homelessness before it reaches that kind of crisis point of rough sleeping and begging is where we would.
And if I was to take your second question there, Ciara, what I would say, again, you heard me mention the need for social housing. I said that earlier. I think that is really crippling us in terms of our ability to prevent and reduce homelessness. There are the numbers in temporary accommodation, it just keeps rising and rising and rising, and that's incredibly challenging. And the main reason for that is because there's not enough social homes or genuinely affordable options available to people. And until we address that, this is going to continue. What's so demoralising, I think, is that, you know, there are people who are experiencing homelessness today who should not be. If we had built the housing that we needed, you know, that's what's tragic to me, because knowing people who've been through this, who go through the harm to their health and their well-being, that's what, you know, is tragic. But we are where we are, and so I mean that would be the number one thing for me. I suppose if you give me a second, I would say, you know, I have the privilege of representing homeless staff in the homelessness sector in Northern Ireland. I consider it a huge privilege, actually, because the staff, that they give everything. So I mean, you know, day in, day out, these are people who are going the extra mile, and they're simply not paid enough for what they're doing. And the lack of funding has been a really significant challenge for us, and will continue to be. I mean, again, we've been in a staff and a recruitment and retention crisis for many years. And I would really passionately believe that if you have a properly funded homelessness sector, you will see better outcomes when it comes to preventing and reducing homelessness. But you can only do that if you have the housing supply. All right.
Well, thank you. And just want to come back on one thing, just maybe to clarify for everyone around Complex Lives, because I have been lobbying for a long, long time with Grania and the housing executive. Actually, obviously, it is quite simple. It's that interagency approach, whether it's public sector, community sector, or local business, all collectively round the table supporting the most vulnerable that are found on the streets that need the most help, and they are doing an excellent job. But it is led by Belfast City Council. Right. It is a small team. It's a one-off project. It hasn't been extended anywhere else at this stage, or is there any plans to? Are you aware of any?
I'm not aware of any specific plans. I am aware that there's been thought given to extending it to the Derry and Strabane council area, but that's as much as I've heard. It's potentially a funding related challenge as well, but certainly I do think that Derry City and Strabane Council should be seriously considering following the same approach that Belfast has. It would look different in Derry City and Strabane because homelessness is different in that part of the world, but I definitely think that that would be our view. We would encourage that for Derry City and Strabane specifically. Yeah.
Okay, thank you. No other members have indicated so far, but could I just ask then, Homeless Connect suggests the option of requiring a report to be produced on the impact of repeal of the provisions. And that would obviously, I suspect, take a form of an amendment or a statutory placing. What form should that report take, and how should the impact be measured to show success?
Yeah, that's a very good question, Paul. And I think what I would say to that is I would suggest that it would need to be an independent external report, not conducted by the PSNI or the department themselves. That would be the first thing. In terms of measuring success, what you'd be looking for would be, has there been evidence of a big increase in either of these? I think that's a valid measure to look at. And then if there had, what would you do to respond further? It wouldn't necessarily be go back to what you had. It might be we need to bring more wraparound support. We need to do other things. So that, I think, again, it would need to take a holistic view around what the impact should be. That would be how I would respond to that.
What sort of period after royal assent would you need to have before you would conduct that review?
I think we've suggested 3 years, but again, it doesn't have to be 3 years. It could be 5 years. It could be another number, but it would need to be long enough to be able to assess the effect.
Yeah. Okay. Well, thank you very much for your time. Sorry, Brian. You want
Briefly,
briefly?
it will be brief. No, again, I was just looking back at my notes from when Professor Brown was in. So on the issue of begging, he had suggested there might be the need for legislation for organised begging, or aggressive begging. What knowledge do you have about organised begging? Is that something you've witnessed or seen in evidence of in Belfast or elsewhere?
Again, I think the PSNI are better placed potentially. I've heard rumour, but it's not helpful to the committee to bring up rumour. It's quite possible that has happened, but I don't have hard evidence of that, so it wouldn't be of any assistance to you for me to suggest at all.
It's not sort of glaringly obvious?
No, not that I'm aware of, no.
Okay, thank you.
Okay, no other member has indicated. Can I just thank you very much for your time and for your evidence and your questions today.
Thank you.
Thank you.
Yeah, if you can respond to the Professor Brown's piece, that would be really greatly appreciated. And
obviously have a discussion with the boss about it.
yeah, and also then I wish you all the best in your recovery, Mark. And I just hope, I just hope that everybody that sees you walk out of this room, seeing you walking in, that's a reputation this committee might not necessarily want.
Thank you, Bob.
Thank you. Okay.
Thank you.
Okay, members, are there anything that comes out of those two evidence sessions that you want to chase up on? I do think we need to chase up on the public space protection orders. I'm not convinced that is a measure that would work in this scenario, but I think we need to explore the potential. I think it would be a blunt instrument is what I'm trying to say, just to exclude people from a very certain geographical area. I just don't think would work. If that is what a public space protection order actually produces, I'm not 100% sure myself. Anybody else want to chase anything up to the department?
Have we had a report on what happens in the Republic of Ireland, the power to move on for begging in certain areas?
Well, we've asked the department for response to Professor Brown's submission.
Okay, that'll be covered in that then.
And that will all be part. Remember, we'll catch all this up when we get the two sessions with the department and the sessions with the PSNI. Okay.
Sorry, Chair, can I check
yeah, sure.
the public space protection orders? Do you want to write to the department on that now, and what, or do you want to just follow it up?
We can pause and wait to. I can hold fire on that until they come up before us. Maybe that would be.
When are the police in?
Come back on it.
Yeah, Glyn said they come back.
When are the police in on this matter?
I'm just going to come to this now. We're just going to discuss that now.
Can I just
go on ahead.
One other thing was Cathy had said she would come back on the housing first model, the other area to roll out.
Yes.
Yeah. We'll chase that up too, certainly. Okay, can I inform members then that as apart from the sessions with the PSNI and the department, today's evidence sessions were the last scheduled evidence sessions with stakeholders on the Justice Bill. The PSNI will attend a meeting on the 27th of November and, if necessary, on the 15th of January. The departmental officials will attend the meetings on the 4th of December and the 11th of December. Committee staff are working to update and format the table of issues arising from the oral and written evidence received by the committee, which will be added to the bill folder. It is proposed that the table is issued to the Department of Justice in advance of those evidence sessions. Can I ask members then if they're content that the table of issues be sent to the department after it be circulated in the bill folder? Members agreed? I think it's good to give that in advance so that they are armed with that evidence when they come. Okay, members content then, we'll move on. Agenda item number 6, Strategic Framework for Youth Justice, Department of Justice Oral Evidence Session. Can I refer members to pages 55 to 112 of the meeting pack for the relevant papers? Can I inform members that today the committee is receiving oral evidence from Department of Justice officials on the Strategic Framework for Youth Justice. The Department of Justice officials providing evidence today are Dr. Veronica Holland, Deputy Director of Rehabilitation and Reducing Offending Division, Stephen Martin, Chief Executive of Youth Justice Agency, and Jenny McAlarney, Policy Official, Rehabilitation and Reducing Offending Division. Can I welcome you all to the committee? You are all very welcome. And can I invite you then to make an opening statement?
Thank you, and thank you to the committee for the opportunity to come and give you an update in relation to the strategic framework for youth justice. Today, as you noted, I'm Veronica Holland, Stephen Martin, the Chief Executive of Youth Justice Agency, and Jenny McAlarney. So very pleased to have the opportunity to give you an update in relation to this, and obviously to answer any questions that you may have in terms of this area of work. You may recall that members had asked for this presentation on the latest annual progress report on the action plan, which were considered by the committee at its meeting on the 18th of September, and the documentation was published on the 3rd of October. So I'm just going to start off by giving a little bit of background and context and providing an overview in relation to the framework, its development, and then to cover progress that has been made to date in relation to that. So the 5-year framework covers the period 2022 to 2027, and it's intended to evidence how the youth justice system has developed and improved in recent years, including the key milestones that have been achieved in relation to that. It sets out a vision for future work of a progressive youth justice system, delivering better outcomes for children and communities. And the original framework action plan that was associated with the document published in 2022 contains 16 actions, almost exclusively led by the Department of Justice along with our colleagues in the Youth Justice Agency, and aimed at progressing one of 4 outcomes. And those outcomes relate to children being exited from the criminal justice system at the earliest point, positive outcomes, custody as a last resort, and partnership working. And obviously a number of those themes are also running through the provisions in the Justice Bill that are currently being taken forward by the Assembly. In terms of the governance associated with the strategic framework, there's an implementation group which ensures a coherent and coordinated approach to delivering the work under the framework and associated with the action plan. The membership of that group includes a range of Department of Justice policy areas, youth justice, voluntary sector members, and those include Youth, VOIPIC and the Children's Law Centre, or the voluntary sector representatives on that group at the moment. And during the last year, the membership was expanded to strengthen our strategic links with key partners. So there's been the addition of representatives from the police, the Department of Health, and also the Office of the Northern Ireland Commissioner for Children and Young People. So in terms of the reporting around the framework, there's a commitment to publish an annual progress report, with the 3rd report covering work during the period 2024 to 2025. And as I say, that was recently shared with the committee and has been published. The action plan that sits under that is very much viewed as a living document, and it's updated annually to take account of both completed actions and reflect any new priorities that have been identified before being published alongside the annual report. And the action plan recently provided to members has been updated to reflect ongoing work and priorities for the current year, that is 2025-26. I'll just now briefly set out some of the key achievements in relation to the first 2 years of the framework, with a range of actions being delivered. So that has included mainstreaming earlier stage diversion and rolling out children's diversions forums to provide children with access to multi-agency early intervention and support, and that's very much aimed at preventing them from moving further into the formal criminal justice system. There's also been delivery of an enhanced case management framework for children who pose a high risk of significant harm or those who have complex needs. There's been public consultation on the minimum age of criminal responsibility. There's also been consultations with children, young people and their families on the experience of youth court and community sentence. And there has been piloting an expansion of the Joint Youth Justice Agency and Health and Social Care CAM services. Also, in addition to that, there has been work to improve employability for 16 and 17-year-olds in the justice system through developing partnerships and improving connections to existing services. Then just moving on to the most recent progress report, and again just to set out a bit of an overview in terms of the key achievements that have been delivered on during the 3rd year of the framework. Queen's University Belfast completed an evaluation of the multi-agency children's diversion forums with an action plan developed to address recommendations from the report. We've also seen the YGA Health and Social Care CAMS approach being fully rolled out across Northern Ireland, and a part-time regional coordinator post has been established with ongoing work with research partners at Queen's and the University of Limerick to design an evaluation of that service. Youth Justice Agency has also participated in the Trauma Informed Oregon pilot to evaluate the organisation's alignment with trauma informed practice, as well as meeting with various organisations to share their knowledge in that area. And this has included presenting their work on developing trauma informed approaches, including at the Safeguarding Board of Northern Ireland's Trauma Informed Practice Conference in January. Then in terms of the consultation and engagement that's been undertaken with children and their families, there have been several new measures introduced to improve their experience in terms of youth court hearings. And this has included updated documentation and guidance for the youth courts, and also new signage to reduce disruption and limit personnel at those hearings, given the age of the individuals that are involved in those. Earlier this year, we also launched new resources to help prepare children for court appearances, including an information video and 360-degree virtual courtroom tours, along with a dedicated web page. So those resources are made available on the Department of Justice website for young people and their families to have access to. And there are also a number of aspects that are linked in with legislative change. The committee will no doubt be very familiar with in relation to these, and officials in the department are likely to be briefing you further in relation to this in the next couple of weeks. So members will be more than aware that there are provisions to amend children's bail, remand and custodial sentencing framework, along with those relating to filtering arrangements and the review of specified offences, which departmental officials recently briefed you on. And those have all been included in the Justice Bill, which the committee is currently considering. In addition, there's also been an options paper was prepared during the most recent year that the Progress Report is covering, taking account of the views expressed during public consultation on increasing the minimum age of criminal responsibility. This was developed and shared with executive ministers earlier this year. There hasn't been any agreement on the way forward in relation to this. Members will no doubt be aware that an amendment has been tabled to the Justice Bill on this issue. And then just finally, a task and finish group has been established to commence work on the commitment in the strategic framework to develop a new single youth community order to replace the existing 7 court orders that are in place. Pre-consultation engagement was undertaken with a range of stakeholders, including children and families and third sector organisations, and that consultation ran from April to July of this year. And we understand that a summary of the responses report is on the committee's agenda for today. We'd obviously be more than happy also to answer any questions that may be raised in relation to that as part of this session. So then turning just to the current action plan. Some elements of the work that I've just covered are still in progress and therefore continue to be included in the updated action plan for 2025-26. And this includes ongoing work on the Justice Bill provisions, the launch of the new youth court resources and finalising proposals for the new single community order based on the consultation that was previously undertaken. And then just in terms of other actions that are being taken forward in year, this includes implementation of the findings and recommendations of the external evaluation of children's diversion forums, work to review and update the new Youth Justice Agency assessment tool and provide improved data on the journey travelled for children engaged with Youth Justice Agency services. There's also been engagement with the Home Office in relation to the introduction of a new civil youth diversion order for terrorism-related offences, which is being introduced across the UK through the Westminster Crime and Policing Bill. Work is also being taken forward in partnership to improve the evidence base on the needs of girls in the justice system and to implement learning and practice. And there's also been engagement with wider cross-executive strategies and other departments in terms of ongoing programmes of work to ensure the needs of children in the justice system are reflected and considered. And then just finally, to touch on the work that's being taken forward in relation to the development of a new cross-executive strategy to reduce offending and reoffending. While this is intended to cover all cohorts of the population, there are obvious links in with the strategic framework for youth justice in terms of the long-term aim to reduce criminality and improve outcomes for all parts of society. The experience of the youth justice system here and the successes we have seen with a significant reduction in numbers entering the formal justice system or being prosecuted at court and a low custodial population will be vital in terms of informing that work in the coming months. So that's a brief overview in terms of kind of the background, the context, the work that's been undertaken over the last number of years, and then also kind of work that will be taken forward in relation to the current action plan. As I say, we're more than happy to take questions from members in relation to that.
Hey, thank you very much, Veronica, for that presentation. I'm just going to put it out to members now. So, Brian.
Yes, thank you, Chair. Thank you for that presentation and your paper. I have two questions. I welcome the partnership approach, multi-agency. I think that's important for young people, and just that collaborative working. An important partner are the parents or the parent, and my involvement with youth involving themselves in antisocial behaviour crime is quite often at interface areas. I'm representative for North Belfast, and when we have multi-agency meetings about this, comments are often made about whether the police or other people, when they bring offenders home, they're not getting a supportive response from parents, and just the importance of parents taking responsibility for their particular authority over their children and influence, and the involvement of social services, when there's a lack of parental responsibility. I don't know, can you speak to that matter, about the approach? Because sometimes parents are not giving, in some circumstances, are not giving the right leadership to their children.
Yeah. So in the Youth Justice Agency then, we don't just work, if a child is referred to us, we don't just work with a child, we work with a family. And family work is a really important part of what we do. Inevitably, we can't, and we're not with a child 24/7, but their parents are. So one of the things that we try to do is scale up the parents as much as we can to deal with issues. A lot of the issues that we generally find, it's not necessarily poor parenting, which is sometimes the perception. There are issues about the relationship and issues about the child's needs. So helping the parents to understand the child's needs. Quite often neurodiversity is a kind of growing issue. So a child who's on the autism spectrum or has got ADHD, so it's equipping the parent to understand A, what the issues are, and B, some strategies for dealing with that. But yes, it's very much a working with a family, not just with the child approach.
And social services can be brought in?
Social services, yes. I mean, certainly if we have a good relationship and we've got information sharing agreements with the trust. So if we have a safeguarding concern, for example, about a child, then we will make a referral to social services. We will do things like case conferences. So sometimes the social worker is already involved with the family, and if that's the case, then we can quite often do a case conference. An education welfare officer also might be involved with a child. So we look at the other services and supports that are currently there and whether they can be strengthened.
Okay, thank you. And the second question, on a similar theme about, I'm a school governor, and I've sometimes heard comments from teachers about not always getting information they need about what is happening elsewhere in their pupils' lives, and I understand GDPR and so on, but what are your protocols regarding sharing information, with schools, so that they're aware of what else is happening, as I say, in the pupils' life, if they have become involved with the Youth Justice Agency?
Okay, so as part of the needs assessment that we have in place that Veronica mentioned, there are 5 key domains. Family is one, education, training and employment is another. And quite often what we find is a lot of children who come to our attention aren't involved in education in any meaningful way, and that's a very significant issue. So one of the things that we try to do is reattach that child to their existing education provision. So that would involve us working really closely with the school and getting an assessment of where the child is and their needs and so on. So we would work with schools certainly around that education, training and employment. If there's not particularly an issue connected with the school or their education, we may not necessarily inform or involve the school, but it is a kind of key domain in our needs assessment, so it would be unusual for us not to have some engagement with the child's school if they're in education.
Right. So the schools is seen as an important partner?
Absolutely.
Yeah,
absolutely.
But you wouldn't automatically inform a school? And I can understand how, in terms of the young person feeling that their involvement isn't brought into every aspect of their life.
Yes.
But but certainly, more commonly, you would recognise the importance of the school, and which is quite often a point of stability, you know, in young people's lives.
Absolutely.
Even though in other parts of their lives there might be less stability. You know?
Well, that's very much so, and we work in a strengths-based approach. So what we're trying to identify is what are the child's existing strengths, and how can we build on those. And education is certainly an area that we try and focus on as much as we reasonably can. So yes, schools would be an important part of that.
Yeah. Okay, thank you.
Deirdre?
Yeah, no, thanks very much for your presentation and the paperwork. I suppose it's just a question around, in 2015 the Justice Act was amended in terms of the aims of the youth justice system to reflect the best interests of the child principles in line with Article 3 of the UNCRC. But your statement of purpose on values doesn't include that, and I was just wondering if there's a reason why, in terms of that international obligation.
Is that in terms of the department or the Youth Justice Agency?
The Youth Justice Agency,
Yes.
in terms of your value statement?
Certainly in terms of our corporate plan, our 3-year corporate plan that I think was shared with the committee a number of months ago, the UN Convention on the Rights of the Child is very much a part of that plan and is mentioned specifically. And we've just been doing some work with Derry and Strabane Council as a lead partner. And Derry and Strabane Council were announced very recently as a UNICEF child-friendly city, which accords. So we very much work to the ethos of the UNCRC, and it's part of our corporate plan. The values of our organisation have been designed with children. So the values that are in our corporate plan are very much designed with children through a participation approach. So
I suppose would they be benchmarked though against those obligations then? Would you assess and benchmark against that, or would you just take consideration of it? I suppose.
I don't know whether we'd bench, because it's very much, you know, the children telling us what our values should be on our statement of values. But certainly our corporate plan is benchmarked against the UNCRC, and it's very much to the fore of our approach.
Okay. The other wee one, sorry, was just in your annual performance impact report. So obviously some good work, around 83.1% of earlier stage diversion referrals were successful. I just wonder what happens with the other, those left.
Yeah.
And I suppose is there mitigations or work being done to try and increase that number, which is a good number?
Yeah, there is absolutely. So we work in a gradated approach, and we try and intervene as early as possible. So we try and our first step is community resolution notices with the police. So this is for lower level first offences, shoplifting, minor criminal damage, some drugs offences. If a child we identify through that process, that's usually a one-off session with a child, and there's only a 7% reoffending rate. But if we identify through our needs assessment at that point that the child needs extra support, we refer them into the thing that Veronica talked about, the children's diversion forums, and then they'll go to earlier stage diversion. So those are children with additional needs that we can't meet. We meet them in 83% of the cases, but sometimes it just doesn't work because something falls, you know, there's perhaps an addiction issue. We don't give up on the child, but, you know, we can't be successful in every circumstance. But our aim is to try and keep the child out of the formal system as far as we can.
I suppose there's no patterns emerging, is there, of certain groupings or, I suppose, vulnerabilities that for that remaining, you know, that say children in care, or as you say with substance issues, or are there any patterns?
Yeah,
or
there are. Actually, I'm just about to do our, because we've just got the statistics for this last year, so I'm just about to do our trend analysis to go to our board. Last year when I did this, there were 2 emerging issues which then became a feature of our corporate plan. One is children in care, particularly in residential homes. We have a growing number of children in the care system who are coming to us for multiple referrals. Girls particularly, if a girl is in residential care, she's a reasonably high likelihood of ending up in the youth justice system, unfortunately. So we've done a lot of research and work to identify the needs of girls. So girls in the system, care experienced young people, and young people who are neurodiverse are kind of an emerging pattern. So we're trying to develop our own practice in those 3 areas in particular.
Funny, a police ombudsman raised that around neurodivergence issues, presenting more and more even through the ombudsman's office, so that's interesting. Clause 12 of the Justice Bill specifies that a period for youth custody supervision orders must be less than 6 months. So obviously children's rights standards would say that they don't allow for a minimum sentence duration, and that they say that detention and imprisonment should only be used as a measure of last resort or the shortest period possible. So just taking in those kind of international children's rights views, just what would be your own view then in terms of that 6 month minimum standard that's in the current bill?
Well, the reason why that was decided was, and there was a consultation in 2014 on the new youth custody and supervision order, and to be honest, the views were equally split amongst those who felt there should be a minimum period and those who didn't.
Yeah.
And you'll know that from the existing juvenile justice centre order, there is a minimum period of 3 months in custody. And the reason why at the time that was decided was research showed that to put children in custody for any less than that time was more detrimental to them in terms of that short, sharp shock. You're taking them out of their home environment, out of school for a very short period of time, and really there's no time properly to work with those children as well.
Yeah.
So we believe that children shouldn't be in custody for any less than 3 months. If the judiciary decide that 3 months is too long, then they should be looking at alternatives like a community sentence instead. So wherever they think that, wherever period of custody should be less than 3 months, they should be given a community sentence and not put in custody at all. So that was the rationale for that decision.
Okay, thank you.
Hey, Ciara.
Thank you. And just first of all, to commend youth justice agencies, to be honest, because it's so refreshing to see a really comprehensive early intervention collaborative approach that's making huge impacts on young people's lives. So first, to commend. I've just a few questions. One would be around Stephen, just that you mentioned about the children in care. Are you part of the collaborative foundation project now with the Department of Health and the Department of Communities? That's just a wee quick one, just to make sure that you are part of that collaboration now with regards to young people in care and working that wrap around obviously early intervention, priority prevent homelessness, but obviously use of a critical role I think they play in being part of that.
Yes, we're part of certainly a number of forums. So I sit on the programme board of the Children's Services Reform Programme, the Ray Jones kind of work. I also sit on a forum with the Housing Executive and Social Services around youth homelessness, and particularly focused on care. And a number of I also chair a subgroup of the Children and Young People Strategic Partnership, and we're specifically looking at offending by children in the care system in a multi-agency way. So yes, we're connected into a lot of forums, and we've got a big focus on doing what we can collectively to reduce the number of care experienced children in the justice system, because it's just too high.
Yeah. And then just something else you mentioned about neurodiversity. We're continuously seeing that even when we're in the prisons, when we're meeting with the PSNI, it's a huge, huge issue. And maybe the lack of support that is available from as soon as a young person meets the criminal justice system. Have you seen any thoughts on what additional support you could have, if you could have access to it, to support the young people with neurodiversity?
Yeah, so one of the things that we put in place during my time as Chief Executive is the CAMS partnership that we talked about. So I think I've mentioned at the committee before, our children struggle with child mental health services because it's a medical model, and if you don't turn up to 2 or 3 appointments, you're out. So we have developed a partnership with Health, funded on a 50-50 basis, where we have a CAMS worker in each of our teams now. We had to find that money from within our own budget. We didn't get any additional money, but it's been really successful. So pre-pilot, 14% of children who we referred to CAMS finished with aim achieved. So they came out the other side better than they started. With our pilot, it was 88%. So we've rolled it out, and that has provided a massive amount of support, particularly for children who are on the autism spectrum, children with struggling with mental health issues. We have a trained professional working with our staff to triage and signpost and refer children and to services and support them. So that's been absolutely transformational. We haven't actually done an evaluation yet, as Veronica might have mentioned. Our plan for this year is, the next business year, is to roll out an evaluation of that service, and we're currently in the design phase with trusts, the Queen's and the University of Limerick, who are our partners on that evaluation.
I just want to maybe focus now on one of the actions is to further develop the bail fostering pilot scheme as an alternative to custody and support successful transitions back into community. it is positive that there has been good outcomes, obviously, from the children involved, but it seems to be very much small numbers since it was established. Can you explain why the numbers for the bail fostering scheme are so low, and more generally, is it your view that the Justice Bill will deliver all the improvements to bail and remand that you consider necessary?
The first bit, and then So if I talk about bail fostering, so the Southern Trust is, in our view, probably one of the more progressive trusts in terms of its thinking. So the bail fostering pilot is a partnership between ourselves and the Southern Trust, funded by the Southern Trust. We've just placed our 6th child coming out of the JJC in that foster placement, which is a specialist placement. The 5 previous placements have all been really successful, and I know the Director of Children's Services in the Southern Trust has been advocating with his colleagues in the other 4 trusts that a similar model should be applied, and we're certainly keen to promote it as well. But ultimately, that will be a decision for the trust because it's their funding it. But so far, it's worked, and it's an alternative to custody in the Juvenile Justice Centre for a number of children who can't return home. Do you want to handle that?
But in relation just to then, do you think the provisions in the bill will help to... Yeah, so I mean, the whole purpose of the provisions in the bill is to enhance our compliance with the UNCRC's requirements around custody as being a last resort. And while significant, improvements have been made in a number of years, and just a significant reduction in the number of children, particularly entering custody in Northern Ireland, there's still the numbers of children who are held on remand are far higher than the numbers then of children who end up having a custodial sentence. So what we really want to do is we really want to sort of ensure that bail is statutory requirement rather than being a presumption of bail. It's statutory requirement for children, and that 2 tests then will be applied whenever a child comes in front of a judge and they're looking at it, whether a decision around bail. They will first have to consider whether the offence for which a child is being up in front of court is an offence which would result in a custodial sentence. That's the first test. So if that test isn't met, then that child should be automatically then released on bail. However, even if the test for that is met, the judge can still consider 4 other sort of conditions around bail, whether or not then it's necessary, it would be necessary to hold a child in remand to prevent certain things from happening, such as the child reoffending or interfering with witnesses or causing a public disorder, their release causing a public disorder or failing to surrender to custody. But if mitigations can be put in place for any of those to prevent those from happening, such as bail conditions, then that child should be released. So we're trying to ensure that children are only held in remand when absolutely necessary and there's no alternative.
Just one final one now. Just the UNCRC committee is clear that when a child or young person commits a crime, the time taken to process it should be as quickly as possible. What would be your assessment of the current efficiency of the juvenile justice system in resolving cases involving children and young people at this moment in time?
I think I'll take the flak for that one because that's probably like to be flak. I mean, to be honest, there are fewer cases in court now, far fewer than there have ever been, but the system is no quicker. I have my own views on why that is, and there's certainly far too many adjournments in cases, and that's causing significant delay. And I'm going to get into trouble for saying that, but it's true. So, in a child's life, I mean, we're currently, for example, supporting a child who's got bail, who was involved in the riots last summer, and is still on a tag and is on bail almost a year after. So the system is not quick enough. A year in the life of a 15 or 16-year-old is a very long time, and it's a long time to have a serious offence hanging over you. So the system is not quick enough, and it's just not good enough. It needs to improve, and we certainly do everything that we can, and we know our partners do as well, but it just takes far too long.
And has there been any research in relation to elsewhere, and particularly in relation to children and young people going through the justice system, the difference between here and now? Because we can all maybe naturally assume that this process is causing more trauma on children and young people, as you say, given the length of time, whether it's stigma or whatever they're going through, awaiting court. So are you aware of any research?
There is obviously Speeding Up Justice Directorate will be the division in the department responsible for looking at that, and I know that there is an ongoing programme of work in order to tackle unavoidable delays, and that's taking a whole system approach in terms of they're looking at reducing demand, freeing capacity, and loads of other different ways to resolve that within the justice system, and children are one part of that, and they recognise the impact, particularly on children, of those delays. But I mean, I think the good transformation funding recently, and there's a big programme of work underway in that.
Yeah, and in terms of that, as you say, Jenny, there is obviously a focus within the criminal justice system more generally to speed up cases going through the system to try and reduce the delay this being encountered, and particularly, as you say, with the impact that there is on children and young people. In relation to the work that's being taken forward by Speeding Up Justice colleagues in the Transformation Fund that was referred to, the focus of that is very much on early engagement and out-of-court disposals. So again, I suppose that aspect in terms of trying as much as possible to take people out of the system where that's an appropriate means through which to deal with them. I appreciate that doesn't necessarily address the issue in terms of the speed with which cases are going through the formal court system, but there is that wider programme of work that the department is taking forward, and as Jenny noted, through Speaking Up Justice colleagues in terms of trying to address that issue. And the focus, as I say, of that transformation vid is very much on that outside the criminal justice system, and trying to ensure that where appropriate cases are taken forward through that route, that there's early engagement, that if an out-of-court disposal is appropriate, that is the way in which those cases are being progressed.
There's no research out there. I'm aware of the wider picture of speeding up justice, but I think children and young people should have a priority in relation across the criminal justice system, whether it's through the courts and at each stage. So it may be something I'll follow up separately as well with the legal profession and stuff, but we need to be doing better, because early intervention is key. The children are the future, and if we're in any way going to change things around, and we can see how it can work across the whole justice system, needs to be prioritising that early intervention work, children and young people. But no, thank you very much. That was insightful.
Okay.
Yeah.
Patsy? Thanks very much, Chair, and thank you for your presentation. Moving on to the education, training and employment aspects, can you tell me there just, there's particular reference here to, say, violent or harmful sexual behaviour offences, and young ones coming from that particular background. Can you explain to me just how the potential school/employer training environment is notified of the level of risk that may be associated with that offender?
So if a child has been convicted of an offence, they will have a criminal record. If they have been convicted of a sexual offence, they may well be signing the sex offenders register. So those details need to be disclosed by an individual if they're applying for employment. And if there are any forms of checks, such as access NI checks, those will appear on those. But the Youth Justice Agency has no role in disclosing offences to others. We don't either have the capacity nor the statutory authority to do that.
GDPR and all that sort of stuff. It's just to make sure that people are protected, particularly if they're going into
the
a classroom.
disclosure of those offences really will be dependent on the type of post that an individual is applying for. So if they're working with if any individual, I suppose, is working with children and young people or with vulnerable individuals, there will be requirements in terms of the checks that have to be undertaken, as Stephen says, in relation to access NI checks, etc. That's probably kind of the primary route through which that type of information would be notified to employers that are taking individuals on that have been involved and have had contact with the criminal justice system.
Okay, and just one other thing, and this was brought into my mind just by events in Ballymena, where apparently kids, I'm not saying they were in the justice system, far from it, they were probably the victims of crime or potentially the victims of crime, just seemed to disappear. What sort of checks do you have to make sure that youngsters, because that's what they are, who are coming out of the youth criminal justice system, that they're checked upon? That because many of them are coming from really, really vulnerable backgrounds themselves. So what's the transition out of the justice system? How is it done to make sure that all the information that's necessary is with the statutory agencies and with any responsible body that might have contact or supervision, or indeed maybe have some form of communication with these kids whenever they emerge from the criminal justice system?
Okay, so if there are safeguarding concerns that come to light whenever a child is working with us, we will make a referral to the gateway team in the relevant trust, and then they will, if it meets their threshold, they will become involved. So then that child becomes part of that kind of system. So there's a well-developed safeguarding system in Northern Ireland. We're members of the Safeguarding Board, and we're subject to the protocols around sharing information and so on, and we do so. If a child, if there's not a safeguarding concern, obviously we're not going to raise it. But if there's a safeguarding concern, we're concerned about their welfare.
Yes.
Then certainly there's a set of processes that come into play.
Okay. Right. Thank you. Thank you, Chair.
There's no other members who have indicated. Can I ask the question then? The minimum age of criminal responsibility, if that was to change to whatever, how will that affect your agencies in an operational sense?
Okay. So there's two ways this could be looked at. Well, if it was raised to an age higher than it is now, in one way you could say that the Youth Justice Agency would have no ability to work with children between the current age of 10 and whatever that age is. But somebody needs to do something with those children, because the last thing we want, because of our focus on early diversion, and the last thing we want is a child turning up at 14 with well-embedded behaviours that create long-term challenges. So I would be keen, certainly, for our agency to be enabled to work with those children on a voluntary basis, if at all possible, but there needs to be some form of work with them, whether it's social services on a statutory basis or us on a voluntary basis. The important thing from our perspective is that there is some work with the child to address the behaviours that are manifesting themselves.
I suppose that's probably something that would be looked at if there were to be any subsequent change in terms of the minimum age of criminal responsibility, in terms of both the legislative changes associated with that, as well as what any outworkings of that change may be in terms of, as you say, Stephen, work that's currently been undertaken by organisations who would then do that going forward and what that might look like.
So who looks after a 9-year-old at present?
If a 9-year-old, if there are issues with a 9-year-old, then we have absolutely no authority to work with that child. So that would be social services if there's a concern.
So if this was to take place, if the minimum age of criminal responsibility was to change, then it would just shift the onus and focus away from a Youth Justice Agency to a social services platform.
Yes, that could be, but we would also be keen, because we can take voluntary cases now, and I approved one today, for example, where we're working with a child who is not on an order, but there's a vulnerability there, and I've agreed that we'll work with that child on a voluntary basis, so we could do that as well, but it would have to be voluntary.
Who did that request come from?
That request came from the parents of the child. It's a child that's previously known to us, so there would be no reason, in my view, that we couldn't do that if the law were to change around.
Obviously, the child consented.
Well, the parents need to consent, yes, and if the child is of 18, but we would prefer the child does consent as well, but that consent isn't necessarily needed. The parental consent is needed.
Mm-hmm. Is there any other, apart from the Youth Justice Agency, is there any other agencies within the Department of Justice that would have an operational change similar to yourselves if the age was to change?
I don't think so.
Mm-hmm.
If the age was to change, we would definitely need a run-in period before that legislation would commence, so that we could put in place a framework for dealing with children under the new minimum age of criminal responsibility, and that would be done obviously with the Youth Justice Agency, with other partners as well.
That raises an interesting point. So if someone was in the system at 10, 11, 12 and the law changed, what would happen to those individuals that were currently in the system that might, well, by the time they get out the other side of the process, the law will have changed?
I suppose in terms of typically what happens with legislation is that your legislation isn't retrospective. So essentially it would be the date at which, you know, it would say, for argument's sake, 1st of January 2026, it would only be offences that occurred after that time period that would fall under the new provisions, or whatever the date may be of any change. Yeah.
Mm. Fascinating. Obviously we have an amendment down. Does the amendment and the age that is stated in the amendment, does that align with the findings of the public consultation undertaken by the department?
Yeah, well, the public consultation indicated very strong support for an increase. So over 83% of those who responded, and there were over 400 responses, I think 450, supported an increase beyond the age of 10. And out of those, I think around 65% supported an increase to 14 years. Some of them may have been less, some may have been more as well. Some supported an increase to 16 or above. But even taking into account as well, I think in addition to the 83%, another 5 or 6% supported an increase as long as there was an exception for serious offences. So really only 1 in 10 people who responded to the consultation were not in favour of any kind of increase at all. So yeah, that would be 14 would be fairly reflective.
Yeah.
Of the views.
And I suppose really the amendment that has been tabled is I suppose it could be deemed to be a halfway house between an absolute 14 and what the current position is. And I suppose, you know, and obviously it's not a departmental amendment, but in terms of kind of the position adopted within it, I really, I suppose, is trying to be cognizant of the fact that there may be concerns from some in terms of, and the Jamie Bulger case is obviously the one that is always cited, albeit if you consider that in terms of the passage of time, and there hasn't been another case that has replaced that as the new Jamie Bulger. But I suppose that amendment in terms of how it's currently drafted is really, I suppose, trying to take account of as many concerns and views as possible. If it's looked at in terms of the wording, as I say, obviously it's not a departmental position, but it's trying to, you know, perhaps give you know, to deal with some of the concerns and issues that some members across the Assembly will have in relation to that.
And again, the amendment, and I'll read it, I'll read part 2. A child aged 10 or over may be charged with murder, manslaughter, rape or assault by penetration. Is the department, have they formed a view on the wording of the amendment as yet?
I suppose the department wouldn't necessarily take a view in terms of an amendment being tabled until such times as it had been agreed by the Assembly. I think from memory, though, that the text that has been included in that amendment is fairly reflective of other legislative provisions in this area. So I suppose there's nothing at this stage in terms of the actual text or the wording, setting aside the issue in terms of you know, the content of as such. I don't think there's anything that would give us cause for concern in terms of the legal wording, if that makes sense, aside from the you know the content. You know.
Preempted me next question, Veronica, so you're very good. Any other members before we tie up? Brian, go on.
I'll just ask that again. I know you asked it. So if a child is below ACR and they're reported to the police for a crime that has occurred, what currently happens? Does being below the age mean they're not guilty or they can't be guilty?
Yeah.
Yes. And so they wouldn't come to yourselves? So does nothing happen, or who gets involved at a statutory level?
Social services, if the police have a concern, there may be social services involvement. So, for example, if a child, I mean, we didn't have this in the summer, but during the riots in the summer, if a 9-year-old had been involved, then there would have been a safeguarding concern about that child, and that would have been a referral to social services by the police.
Right. And a referral to social services, what is the compulsion in that? Is it, from the point of view of the child and the parents, is it a voluntary involvement then? Or
if there's
a safeguarding concern?
Yeah, so I'm not a social worker, so I'm probably not the best person to answer this, but my understanding is that an assessment would be done around whether that child has particular needs and there are concerns about the arrangements, let's say the parental arrangements affecting that child, and it would be treated as a safeguarding issue.
Yeah.
As far as I'm aware.
If social services had genuine concerns, and the parents were to say, or the child would say, look, we don't want you involved here, they would still have some statutory authority to...
Yes, that's my understanding, yes. Yeah, under the Children Order 1995, yes, they would.
Yeah. Okay.
Okay, no other members have indicated, so just remains for me then to thank you for your time and your presentation and your answers, so thank you very much.
Thank you.
Okay, members, moving on then. We have a lot to get through here and we are pushing time here. So agenda item number 7 is Justice Bill Live Links Amendment Raised Written Paper. Can I refer members to page 114 of the meeting pack, which contains a paper by the Assembly's Research and Information Service providing an overview of the planned amendment to the Justice Bill regarding live links within the Northern Ireland Courts and Tribunal Service. Can I inform members that the paper provides an overview of the powers that the various clauses in the live link amendments will deliver, what the measures will mean for court proceedings, information on research studies that explore the impact of remote court proceedings on participants since COVID-19, the outcome of the consultation and the position of other jurisdictions. A number of scrutiny points have been highlighted in the paper, which begin at page 141. Can I remind members then that after reviewing the delegated powers at last week's meeting, the committee has already asked the Department for details of the matters that it is envisaged that the court should have regard to when determining the use of live links under the regulation making powers, which is one of the scrutiny points at page 142. But could I seek members' agreement then to forward the paper to the Department for its response on the remaining scrutiny points? Is that okay? Agenda item number 8 then, Justice Bill Written Papers. Can I refer members to pages 144 to 150 of the meeting pack? Can I remind members that at its meeting on the 16th of October, where members heard oral evidence from Northern Ireland Alternatives and Community Restorative Justice Ireland on the proposed restorative justice amendment to the Justice Bill, the committee agreed to write to the Department of Justice seeking clarification on a number of matters raised in that session. Can I inform members that the Department has now provided a response to these questions? Can I ask members if they are content to note the Department's response or if any further information is required? Deirdre?
It's just the same as that. Can we share this with the restorative justice organisations as well? Thanks.
Yep, and ask them even for comment?
Yeah, please.
Okay, members, moving on. 8.2 Justice Bill request for further information. Can I refer members to page 151 of the meeting pack, which contains the latest version of the document prepared by the committee team to track committee requests and responses received in respect to the Justice Bill and proposed amendments. Can I seek members' agreement to note the list of requests and responses? Great. Agenda item number 9, Crime and Policing Bill, Legislative Consent Correspondence. Can I refer members to page 189 of the meeting pack, which contains an update from the Department of Justice in relation to a Crime and Policing Bill, second legislative consent motion. Can I inform members that the Department has advised that the progress of the bill has slowed further at Westminster? Under the current schedule, the Department is hoping to achieve executive approval before Christmas and then lay the LCM in the Assembly short thereafter. The Department has also advised of 2 further measures which are to form part of the bill that the Minister is keen to extend within this LCM, subject to executive approval. These measures are a power to provide for defence for authorised technology testing activities. Specifically, it will enable technology such as artificial intelligence models to be tested by organisations authorised by the government for prohibited material without offences being committed in the course of that testing, and then another offence to criminalise and the possession and publication of pornographic images depicting strangulation or suffocation. Can I ask members if they are content to note the update or if any further information or clarification is required at this time? Deirdre?
It's just a big cap update. Just that the NI Scrutiny Committee and the Lords, Lord Carlisle had raised concerns about the Human Rights Commission concerns in terms of clause 71 and the compatibility with. Oh, are we on the first one?
Yeah.
Sorry.
I'll come on to that.
Yes, sorry, no,
it's about the LCM, just about the 2 new offences.
Yeah, no, we're content enough with those, yeah.
Okay, if you can hold your waist 1 wee minute.
Yes, 100%.
Advise members that the House of Lords Northern Ireland Scrutiny Committee has provided a copy of its correspondence to the Minister for State of the Home Office regarding clause 71 on the Crime and Policing Bill. This is 9.2 House of Lords Northern Ireland Scrutiny Committee Crime and Policing Bill. Can I remind members that having received previous correspondence from the Northern Ireland Scrutiny Committee, the committee agreed to ask the Department of Justice for its view on the Northern Ireland Human Rights Commission comments on the compatibility of clause 71 with Article 2 of the Windsor Framework and for details of any engagement that the Department may have had with the Home Office on this matter. However, the Department has advised the Clerk that it is not yet in the position to respond to that letter. So Can I seek members' agreement to forward the correspondence at item 9.2 between the Northern Ireland Scrutiny Committee and the Minister of State to the Department for information? I'll bring you in now, Deirdre.
Yeah, it's just obviously Lord Carlisle has asked for a response from the Home Office because he wasn't content either with the assurances, and he wants that by November the 20th. So it's just if we can be kept updated on the feedback to his request as well, I think that would be good. Thanks.
Okay, any other members on that? No. Okay, agenda item number 10. I'm just mindful of quorum here, members, so if we can all stay. Agenda item number 10, new single community order for children, outcome of consultation, Department of Justice written paper. Can I refer members to pages 198 of the meeting pack? Inform members that the Department of Justice has provided the committee with the outcome of its public consultation on a new single court-ordered community sentence for children, which will replace the 7 orders currently available to courts. The key findings from the report has been summarised in the Department's paper, which indicates that there are significant support for the introduction of a new single order. The main areas of divergence are around curfews, exclusion requirements and electronic monitoring through the Department points, though the Department points out that those are currently options for youth conference orders. The Minister has approved the summary report for publication, and the Department has advised that it is continuing to work with partners to both develop the proposal into a single working order and to identify suitable legislative vehicle to take the new provisions forward in the next mandate. So can I ask members if they are content to note the update, or if any further information or clarification is required at this time? That's great. Agenda item number 11, court fees 2026 to 29, outcome of consultation. Refer members to pages 261 of the meeting pack. Can I remind members that at its meeting on the 10th of April, the committee noted a paper from the Department of Justice advising of the Northern Ireland Courts and Tribunal Service's intention to run a public consultation on changes to court fees during the period 26-29, and agreed to consider the matter further when the results of that consultation were available. Can I inform members that the Department has now shared the outcome of that consultation with the committee and invites members' views on its draft response paper? The Department is also seeking the committee's approval to proceed with its proposed changes to court fees. The specific changes that the Department intends to proceed with at this time are set out at points 1 to 6 at paragraph 85 on pages 282 of the meeting pack. The draft fee schedules are provided at item 11.3 beginning at page 285 of the meeting pack. If members are content, the Department has advised that the Courts and Tribunal Service will progress the necessary amendments to the fees order legislation and seek approval for 6 SL1s and draft statute rules at the committee's meeting on the 27th of November 2025. Deirdre?
Just with the consultation responses, there were some concerns in terms of how this was disproportionately impact on some vulnerable groupings. So I would be keen, before we agree this, that we look at what equality screening was done. Did that throw up a disproportionate impact on more vulnerable groupings in terms of access to justice? And if so, what mitigations the Department could potentially put in terms of mitigating against those negative impacts?
Okay, any further comments, Brian?
Yeah, no, just similar to Deirdre. For family courts, that you wouldn't want access, financial ability to be a barrier for people needing, exclusion orders and things like that. So, we presume that legal aid is available, in circumstances. So, if we can get that clarity.
Okay, so we've sought we'll seek agreement to ask those questions.
The Chair, could I maybe ask another one? I think too could be asked the Department. Are they considering calling for a review mechanism, that a review mechanism is included on an annual basis to see how effective these changes are, and if they're performing better than the 84% that they were able to claim back before these changes? And then just how do these increases fit in with access to justice and speeding up justice, which is the 2 core elements that would be key, just to see the benefits of this as well.
So are members content to note the paper but will not say anything with regards to proposed changes yet until we get clarification on those points? Okay. Agenda item number 12 then is correspondence. Can I inform members that there is a correspondence memo and 20 items of correspondence at page 332 to 659 of the meeting pack, and 2 additional items in the tabled pack. Can I advise members that I will draw their attention to 12 of the items, some of which refer to the same matter and will be considered together, and then members will then have an opportunity to comment on any other items of correspondence they have a particular interest in. Items 12.2, 12.3 and 12.4. Can I inform members that these items at pages 334 to 348 of the meeting pack contain responses to the matter of access for students to the Bar of Northern Ireland from the Department of Justice, the Department of Finance and the Department for the Economy respectively. Can I ask members if they require any further information or clarification on any of the items of correspondence? No. Can I? Sorry.
I think there is still a concern. I know this came up in the Finance Committee the other day, myself and Brenner on it. But I am still concerned around the lack of action, particularly for working class people accessing, getting into this profession, or if you don't have a family or relative that's already in the profession that can give you work. And I just don't know if the answers are fully satisfactory, to be honest. So I think it is an area that, I don't know what the answer is, but just an area that we should still probe or to look at in a bit more detail.
Okay, Brian, you want to add to that?
Yeah, no, as Deirdre said, we discussed this yesterday at Finance Committee. I think there's 4 inns of court. It's quite an antiquated system. Talk about bars and inns, you think you were talking about something else, but anyway, the 4 inns of courts in England, there's one here, and it's just understanding how they're funded. Are they the scholarships almost, I understand to some extent, so I'm not sure is it public funding or is it private funding, which supports, because of speaking to young barristers in the past that realise a lot of them don't get any income if they don't do, they have to basically, it's a casework they get, so that they have to get cases. They're hanging around the courts hoping to get something. I think it can be very low wages at the start. So there is a consequence for those that don't have some wealth to fall back on. So I think we should ask more questions about what funding is available.
Given that thought, then, can I seek members' agreement to forward all of the departmental responses to the individual who raised it in the first place, and then also you could invite feedback in that regard?
Agreed.
But it's important, that there is access, into as a career path for people. If it's an old system, where it's very difficult to get into, they're no different to any other profession, teaching, policing, that there should be support available.
Yeah.
Especially at the entry stage, because otherwise that becomes a barrier.
Yeah. Cathy, you want to come in?
Yeah, Chair. I suppose what I wanted to ask is if the committee wants me to maybe have a chat with our researchers in terms of what happens with the inns in England and here, and whether there are scholarships available, and possibly even what happens in the Republic of Ireland as well. It might be a starting point. The only thing I would caution there is that I know that Rays are busy and they've got other work on for this committee as well at this point in time, so it might be a little bit of time before that comes back, but it could be worth exploring.
Yeah, I think so. Members agreed? Yep, okay, thank you, Cathy. Item then 12.9, can I refer members to page 359 of the meeting pack, which contains a response from the Department of Justice to questions the committee had asked in relation to unlawfully at-large individuals. The Department has advised that the matter in question mostly relate to PSNI operational matters, and the committee may wish to direct its queries to the Chief Constable. Can I remind members that the committee has also written to the PSNI on the issue of individuals at large, and members may wish to consider that response when it is received to determine what other questions they may wish to ask of the PSNI. I know Doug had raised this previously, as had others, but can I ask members if they require any further information or clarification from the Department on this issue, and are they content to wait till we get the PSNI response too?
Yeah,
okay.
content.
Item 12.10, refer members to page 362 to 367 of the meeting pack, which contains a response from the Department of Justice to questions the committee had asked following its consideration of the update on the Department Speeding Up Justice programme. The response notes that the decision on which court to prosecute offences relating to non-fatal strangulation rests with the Public Prosecution Service. So can I seek members' agreement to ask the PPS for information on the number of cases related to non-fatal strangulation to the Magistrates Court and the Crown Court, and the reasons why this is the case?
Great, yeah.
Okay, great. I ask members if they are otherwise content to note the department's response, or if have any further information clarification is required. Content?
Content.
Item 12.12 then, refer members to page 392 of the meeting pack, which contains a correspondence from the Assembly and Executive Review Committee in relation to a review to conducting into the development of a formal process and guidance on the handling of Westminster statutory instruments, which includes a role for the Assembly because they impinge on devolved matters. Can I inform members that the Clerk of the AERC has advised that following consideration of correspondence from the Committee of Communities in relation to a Westminster statutory instrument that falls within the scope of the review, the AERC is now asking all statutory committees for examples of any stat rules that they may have handled that are similar to examples shared by the Committee of Communities. So can I seek members' agreement that committee staff prepare a response for consideration and agreement by the committee prior to issue to that committee? Members agreed. Item 12.14, can I refer members to page 401, which contains a correspondence from the Health Committee in relation to its committee stage work on the Adult Protection Bill. Can I inform members that the Clerk of the Health Committee has advised that there are a number of provisions within the bill which may be of interest to the Committee of Justice. The Clerk has requested that any response the Committee may wish to make should be forwarded by the 5th of December. Can I seek members' agreement to ask the Department for its views on the provisions that are relevant to the justice sector?
Yeah.
And then can I ask members if they have any comments that they would wish to make at this stage for inclusion, or any response that the committee might wish to make to the Committee for Health? I maybe could suggest, even if you consider that and think about it, and maybe even bring it back next week if we have time. Can I refer members then to 12.15? Refer members to pages 401 of the meeting pack, to pages 3 to 10 of the table pack also, which contains correspondence from the Causeway Coast Dog Rescue. Can I inform members that the organisation has written to the committee to request a formal investigation into the presence, management and welfare of animals housed within Northern Ireland Prison Service facilities? The request is in response to a well-documented case of welfare concerns surrounding a support dog at McGilligan Prison, as well as other animals at prison service facilities. The correspondence outlines a number of areas of concern, as well as the offering of recommended solutions. The correspondence also requests that the matter is raised formally with the Justice Minister and an immediate investigation is conducted, and that the committee seeks clarity on whether DAERA is involved in the matter as required under the Welfare of Animals Act, Northern Ireland 2011. Can I seek members' views on how the committee wishes to respond to the Causeway Coast Dog Rescue? If there are no... Cathy, do you want to speak to this? Or...
Well, Chair, really, it's for the committee to decide whether what it wishes to do. I suppose I know that the correspondence refers to not getting satisfactory answers from a number of organisations. So it may be that the correspondence needs to actually then be referred to the complaints processes within those organisations, and ultimately then the NIPSO. But I would also suggest that, while this isn't necessarily an individual case, like the committee has its procedures in that regard, because of the work programme and because of the legislative programme, the committee may not be able to become involved in matters that are not directly related to its strategic priorities or to its statutory duties, because it just doesn't have the capacity to do so. So if the committee is content, we can respond to the individual or the group in that capacity.
Okay. Connie?
Thanks, Chair. Yeah, I would be content with what the clerk suggested, and maybe we could also direct them to. I think there was an independent inspection done on this issue. I think that report is on the DOJ or the Prison Service website. It might be helpful if we could inform them of that as well. But I think I agree with what the clerk has said there.
Okay, members agreed then? Okay.
Just we're going to ask the department for a response.
No, we're going to go back to the group and say, look, there is a complaints process that you can do with regards to the departmental responses, and then you've also got the Public Service Ombudsman if you're not content at that point.
I'm just surprised the list of animals that they're in the correspondence, right? So we don't have verification on that, then, do we, from the department?
No, just other than the letters that we've received from the group.
Right.
At some point in the future, we'll have prison service up, and at that point, then we maybe could be probing that type of thing.
Yeah.
Okay.
Yeah.
Okay.
Item 12.16, refer members to pages 483 of the meeting pack, which contains correspondence from the Neurology Action Group requesting the tabling of an assembly question to the Health Minister regarding the Department of Health's ownership of Crown indemnity, its role in funding and authorising defence costs in neurology recall cases, and its formal status as a notice party in a legal case. Can I seek members' views on how the committee wishes to proceed or to respond to neurology action? This is a wider issue, I think, than really this committee, and there are issues. There is the Law Society that can be called upon and requested action from. So I do think that's maybe where we need to look to. I don't know if there are any other comments, or if the staff want to raise any solutions or actions that could be borne out.
No, Chair, just to check if the committee's content to note, and it's not, committees don't have obviously the capacity or the facility and to table questions in this way either. That would be for an individual member to do.
And any member can.
Yep. Yeah.
Okay, agreed. Item number 12.18, can I refer members to page 491 of the meeting pack, which contains further correspondence from an individual regarding an ongoing personal matter. Can I inform members that the clerk has provided a memo outlining the broader context of this correspondence and advising that there continues to be no apparent role for the committee in relation to the latest correspondence. So can I advise members that the clerk has prepared a draft response for considerations at page 498 of the meeting pack, reiterating the committee's position in relation to the matter and providing contact details for the Minister of Justice's office. So can I seek members' agreement to issue the draft response to the individual?
Agreed.
Item 12.20, refer members to page 491 to 496 of the meeting pack, which contains an invitation from Amnesty International to a briefing event on new legacy legislation, rights and rule of law, where to next, in room 115 of Parliament Buildings next Monday. Members were asked to RSVP by 4 p.m. today should they wish to attend. And then members, item 12.23, can I refer members to pages 10 and 11 of the tabled pack. Members will be aware of media reports in recent days regarding a potential withdrawal of services by the Criminal Bar Association. Can I advise members that the Bar of Northern Ireland has provided an update on the position of CBA, which was circulated to members earlier in the week for information. Can I remind members that the committee will hear from the Permanent Secretary next week, which will be followed by oral evidence from the departmental officials on the Enabling Access to Justice programme. So members may wish to take the opportunity to raise this matter during either of those evidence sessions. Can I ask members whether they are content to note the other items of correspondence as set out in the correspondence memo, or whether they have any comments to make on any of the items?
Noted.
Okay, noted. Agenda item number 13 is Forward Work Programme. Can I advise members that the latest draft of the committee's Forward Work Programme is at pages 661 of the meeting pack? Can I seek members' agreement to the Forward Work Programme? Subject to there's no changes today, so happy enough? Yep.
Agreed.
Agenda item number 14 is Chairperson's Business. Can I inform members that I have received a letter from the Lady Chief Justice offering congratulations to myself on the appointment as Chair of the Committee and commending the strength of the relationship between the Committee and her office, something that we'd be keen, of course, to strengthen further. Can I inform members that in her letter the Lady Chief Justice has also offered an invitation to host the committee at the Royal Courts of Justice for a meeting sometime early next year. So could I seek members' views on whether they wish to take up that invitation and explore scheduling a meeting with the Lady Chief Justice early in the new year? Can I also add to that if we are going down, if there be provision there, we could maybe hold one of our committee meetings there.
No, that's what I was thinking too, yeah.
That'd be the way to do it then.
Okay.
Most of the time some of us will have other committees probably.
Yes, of course.
Unless it's on a Friday, whatever. But it's the only day you get in your constituency.
Yeah, of course. Yeah.
It is my constituency.
Agenda item number 15. Any other business then? Have members, can I ask members whether they have any other items of business do they want to wish to raise at this stage? No? Again, agenda item number 16 is date, time, place of next meeting. Can I advise members that next meeting will take place on Thursday, 20th of November 2025 at 2 p.m. in room 30 in Parliament Buildings. I adjourn the meeting.